Going to start our sessions. We are now focusing on victim consent. We are looking at the case digest, chapter 4, particularly 4.4. And so we'll be looking at issues that present themselves in terms of consent. Did the victim consent? What type of consent is it, and can it be called consent? So without further ado, we'll start with in the order that the presentations appear in the program. We start with Mauritius, the Sonar case. Seychelles will present Alam. South Africa will present Alima, Eze, and Obiaba. Again, I would just request that you look at me from time to time, and when you're running out of time, I'll hold out this yellow piece of paper, the yellow card, and that tells you you have 2 minutes left. I don't have a red card, so go ahead, Mauritius.
Hi, colleague. Good morning. So, as regards the Sonar case, the facts and circumstances of the case are as follows. On the 24th of January 2009, a team of police officers in uniform and civilian dress proceeded to a beauty parlor to have a check because there were complaints that illegal activity were taking place thereat. Luckily, when police arrived on spot, the owner, as well as his son, were present, together with 3 other ladies who were at the reception desk. The police informed the purpose of the visit, and the team of the officers carried out a check in the room. They also checked the license of the premises, beauty parlor. The license was to be found duly in force. However, during questioning, it was found that there was a minor who was recruited thereat. Therefore, the police asked all the 3 ladies and the minor to accompany them at the police station. On spot, there was no any incriminating evidence. So when the minor was brought at police station for questioning in presence of his parent who were summoned to attend the police station, there and that it was found that she was recruited by the owner for prostitution purpose. The minor stated that following an advertisement in the newspaper as a receptionist, she went at the parlor. She was interviewed by the owner, and the owner told her that she will have also to work as massage therapist. She was recruited, but after 2 to 3 days, the owner informed her that beside being a receptionist, massage therapist, during the massage, he will have to do a masturbation session. The masturbation session will be 2 per day, and it's only if she agrees that he will receive her salary at the end of the month. Being in difficult situation, she agreed to the proposition until that police raided the beauty parlor. The 2 other ladies also stated that it was following an advertisement in the newspapers as babysitters and receptionists and massage therapists that they were employed. And it was also the same rules used by the employer that after 2 to 3 days after the recruitment, that they were informed they have to do massage with masturbation, 2 sessions per day in order to receive the salary monthly. As regard the female person who were of age, one of them accepted to the proposition because she has just left her husband. She didn't have any place to live. The owner even provided her with a house where she can reside. So she accepted, he consented rather to the proposition. The third female person also accepted because she was in financial difficulty. So here we found that the ruse or the trick used by the employer, she makes advertisement, she recruits them, and after 2 to 3 days, he proposes them to have the massage session and the masturbation, knowing well that they were vulnerable. She exploited the vulnerability of this person. You will see that the minor as well as the 2 female lady consented. So there was consent. We can say, or we may say that if the victim are consenting, whether it is not a weakness on the part of the prosecution case, but as pointed out previously during the seminar, that we can, even the weakness, it can be used to prove that there was a control. The consent given was with fraud, and when the case was heard in court, the magistrate has the opportunity to see the demeanor, to assess the credibility of the witnesses. During the trial, the magistrate was convinced by the demeanor of the trial, of the minor. The age was proved through the production of birth certificate. The other 2 female witnesses also deposed in the same direction. They established the modus of the recruiter, of the owner, the proprietor of the beauty parlor, and based on all these evidence, the prosecution was able to secure a successful prosecution. There was admitted fact on the part of the accused party that he made the advertisement, he employed he recruited the ladies as well as the minor, and the accused was prosecuted for child trafficking in respect of the minor for the purpose of exploitation, that is prostitution, as well as the second count in respect of the 2 ladies that he exploits them for the purpose of prostitution. Thank you.
Thank you. Since you still have a minute, do you have the sentence? If you don't, that's fine.
No, I don't have the sentence with me.
Thank you very much. Let's move on now to Seychelles.
Yes, good morning. I shall give a brief overview of the case, and my colleague will discuss the matter of consent. So you have one individual called Mr. Alam, who came to Seychelles and got into the construction business. And as it is very common in the Seychelles, due to our limited workforce, we do employ a lot of foreigners of Bangladeshi, Indian, and Asian origin. And Mr. Alam, at one point, started a business and employed some Bangladeshi from his own country, as he was a Bangladeshi himself. And these Bangladeshi, they would secure large sums of money by loans, and they would have to pay Mr. Alam to secure an opportunity for employment in the Seychelles. This was known within the trial. And when they would arrive in Seychelles, we were told that the agent in Bangladesh was in fact the brother of Mr. Alam in Seychelles. So half of the money will go to the agent in Bangladesh and half to Mr. Alam in Seychelles. And when these workers will get into Seychelles, they are quoted in the case law as ARFCLM and MH as to secure their identities. They will pay half of the money in USD, US dollars, to Mr. Alam, and he will take their passport from them. Initially, when Mr. Alam applied for working permit in the Seychelles, the 4 workers, Bangladeshi workers, was meant to work on an island called Pralin, specifically. Our working permit is quite specific. Unless you want to make an amendment, you would have to seek the approval of the authorities. But at some point, Mr. Alam moved the said workers to another island, the main island named Mahe Island. It seems that he was facing some financial problem, so he would subcontract the workers to other contractors, which is again against the working permit. And he would retain their passport. He would not pay them their salaries, even if the subcontractors will pay him directly their salaries. At some point, the immigration authorities were informed, a tip-off, as per the proceedings. It seems that as Mr. Alam was responsible for the accommodation, the food, and everything else, he was not doing so. The workers would argue that they were not paid, they were not fed properly, and then the authorities got involved to investigate the matter. The workers will stated that they have not been paid for months. They've been working long hours during the day, and because they were living in a deplorable accommodation, which the authorities demanded that Mr. Alam move the workers to a more conducive accommodation. So what Mr. Alam did, he deceived the authorities. He would have subcontractors, he would have a deal with subcontractors and say, look, I'll finish your house, so as long as you let my worker live there, so you can imagine it's an unfinished house, they are living there whilst they do the contracted work from 5 during the day. Then from 5 until maybe 10 in the evening, they would also work on the subcontracted house that they were living in. When the authorities got hold of the whole situation, the police, immigration, the Attorney General's office got involved. Mr. Alam was prosecuted. There were ample evidence. You had the evidence of the 4 victims themselves. You have the Public Health Authority, who witnessed their deplorable conditions. You have the witnesses of the subcontractors, who claim that the employees were not fed properly. They claim that they had not been paid for months. And you had the evidence of the employment department, which the same team came out. And Mr. Alam got a sentence of 3 years imprisonment and a fine of 400,000 Seychelles rupees, which if he failed to pay, he would suffer another 2 years. Unfortunately, he didn't pay, and he got 5 years in total. Our laws states that if you are found to be convicted of such an offense, you may suffer 14 years imprisonment and a higher fine. And if there are aggravating circumstances, you may suffer 25 years in imprisonment. I personally, with all due respect, with the jurisdiction of the court, we were satisfied that we got a conviction, but I personally felt that the law gave the court more space and the sentence could have been more harsher, more. So this will be the case, and my colleague will delve into the issue of consent. Thank you.
Good afternoon, everyone. Bon après-midi à tous pour ceux qui parlent le français. I'm going to take on behalf of my colleague here, Mr. Cado. So directly, we're going to talk about consent in regards to the specific case of Alam. Now, in Seychelles, when it comes to the consent of victim in prohibiting trafficking, we do not take this into account. Consent for us, when the prosecutor needs to prove their case, is irrelevant. Rather, what the prosecutor needs to prove is that the means of which the person were recruited, transported, falls within the category of Section 3.1, which covers, was there threat, use of force, fraud, deception, power of abuse, or G, which is giving or receiving payments for benefits, knowingly or intentionally. So if the prosecutor can prove that the trafficking was made by any of these means, you could secure the conviction of the said accused. Okay? So with that regard, although that consent is irrelevant in order to obtain the conviction of the accused, we can, from the case of Alam, see consent in two parts. First of all, we can look at the fact that the victims, there was no one that provided an informed consent. Okay? So they were told that they were coming to Seychelles to work. Some of them, one particular, if was LM, who was stated that, okay, you're coming to work in Seychelles, in Sicily, Europe, as a caretaker. But then he found himself in Seychelles on a tourist visa. Okay, so what he had consented was not what he received at the end of the day. And many others, three other victims, found themselves in the same situation, as explained by my colleague here, in which, yes, they stated that they came to Seychelles to work as a construction worker. They would be working for the Dove Alliance Limited, which was a company of the accused, but then found themselves being subcontracted to other contractors. Had they known the reality of the situation, surely they would not have consented to these terms and conditions prior to coming to Seychelles. So this is just a little bit about the consent prior to coming to Seychelles. Now if we take a look in the sense of when in Seychelles, the voluntariness of the parties, the victims rather, when they were in Seychelles, we see that, as stated, they were made to give their passports upon reaching Seychelles. Truly, there was no voluntariness in that. That was the accused forcing them to give the passport to ensure that their movement is restricted so that he can obtain full possession of them and can do as he wants with them. Okay, then we found that many of the works that they were doing, they did not want to do it, but the victim had threatened them. One was particularly threatened with a knife. He did not want to work, but the accused said, look, if you don't work, I'm going to assault you. No voluntary, again, still had to show up to work, do the work, whether or not he liked it. Then we find that there was fear. the accused made sure that each and every time the parties would complain about the accommodation, the salaries, the fact that they were receiving little or to no food for that matter, because at one point they were begging the subcontractors to provide them with food, he would induce fear of deportation on them. So coupled with that, you will find that there was neither consent before coming to Seychelles or during that time whilst in Seychelles. So with that, I would definitely put forward that this helped to further prove the case, even though the prosecution did not have to prove it in order to obtain a conviction, but it surely did aid in the sense to show that these victims were being mistreated, and they were treated in the sense that it was indeed trafficking in persons. Okay, thank you very much for your attention.
Thank you very much, Seychelles. Let's now move on to South Africa. I believe some will be joining online. Is that, or it's just the three? Okay.
If we can maybe get the presentation. I don't have the click either to change the slides. I saw it this morning. Oh, there. Thank you. Thank you. Okay. Good morning, colleagues, again. Yeah, South Africa has very similar legislation as Seychelles in terms of consent. We also have a section within our TIP Act that indicate that the victim cannot consent to an intended exploitation. However, in the cases that we are here that South Africa is discussing, South African cases of ABBA, State versus ABBA and State versus Easy, both the accused in these cases, their defense had been that they were not responsible for the exploitation of the victims. They were merely providing the victims with either accommodation or romance. In one instance, the victim thought that the accused was her boyfriend, and that the victims, due to their own psychosocial problems, became vulnerable. In other words, they were all four victims in these two cases. Each case consists of two victims, were vulnerable because of drug addiction. The facts of the matters, both these cases, were that both victims were drug addicts and had actually used the accused as their drug dealers when they when they fell into debt with the accused and had to start doing prostitution to earn money or to pay off their debt to the accused. But in both these cases, the expert psychosocial evidence on tip victimology and tip perpetration was able to rebut the allegation by the defense of uncoerced consent by the victims to be prostituted. Consent in South African law would also mean uncoerced permission or agreement. Our legislation on sexual offences specifically indicate that coerced consent is not consent. We have discussed it very briefly yesterday in terms of what an expert witness is. An expert witness has the necessary knowledge to assist the court due to special skills and training and experience that qualifies the expert to express an opinion on a certain topic. And as we've said yesterday, the amount of degrees or qualifications is not the determining factor, rather the skills and experience would be. Also, the expert has to the expert also the opinion must be based on proven facts. And it must be based on the facts of the matter. It cannot be based on the hypothetical facts. As we've seen, as Rahel had also pointed out yesterday, unfortunately, the childhood experiences of our victims very often determine the extent of their vulnerabilities. And we've seen there in ABBA as well as in Easy cases, both these all four these victims had actually suffered severe adverse childhood experiences. In Abba, the one victim was orphaned very early in her life and had absolutely no parental care until she came to South Africa to start living with a very distant family. It seems like it didn't turn out to be a very caring environment either. The other victim left her home her parental home when she discovered her father is not her real father but her stepfather, clearly indicating huge dysfunctions in that environment. Otherwise, the victim's reaction wouldn't have been that excessive. In the easy case, both victims were sexually abused. The one was sexually abused by a family member. The other one was raped at age 6 months by her father. Both of them ended up in the welfare social system and started using drugs at a very early age. In the control mechanism as well as vulnerabilities used by ABBA was very similar to that used by EASY. In other words, what they do is they exploited the already vulnerable victims who were already drug addicts, very, very young women, Abba's the first victim was early 20s, and the second victim was she was in her teenagers. I think she was just turned 18 or 19, but she was very young. Both of them were already doing prostitution when they encountered the evil Abba and his colleagues, and his fellow accused. And both of these two victims were controlled by drugs. Both of them got a wake-up drug to increase their libido and decrease their inhibitions. They were always also severely punished with severe assaults if they did not abide by the rules set by the traffickers. And I also want to point out that the victim one was witness to other women being severely assaulted, including the second victim who tried to escape, was caught and brought back to the trafficker and severely assaulted. Accused two, the victim two, exactly the same. The victim two was also severely assaulted in front of the other victims, and also added that accused number one was trained by accused number three to run the business, while accused number three was absent in Nigeria. The expert evidence in ABBA was specifically related to the push and pull factors. In other words, why you can never regard the interaction of the victims with the accused as consensual, because it was not uncoerced consent. The coercion to coerce these women into these vulnerable positions where they can exploit it was evidently the modus operandi that these traffickers operated on. The push factors was explained in the ABBA case by the expert as unemployment, poverty, and dysfunctional households. We see both our victims came from that environment, and he called the pull factors the lure of city life, job opportunities, or of course in these victims' cases, drugs. And the control methods with drugs and violence, he refers also to the symbiotic relationship between the victim and perpetrators, where the victim becomes totally dependent on the perpetrator for all her basic needs. Such relationships, he said, would often result in coercion, violence, threat, and manipulation. And the next one. Easy also, exactly the same control mechanism. Again, he exploited already women, very, very young women, already drug addicts that were already doing prostitution due to psychosocial circumstances or due to their drug addiction. What is important, he also allowed the first victim to see her parents on her birthday, but it was under his constant supervision, an aspect that that was mentioned by the defense that they tried to rely on to indicate that the consent by the victim was out of her free will and that she was not coerced into consenting to do sex work for his benefit. He also gave her wake-up and sleeper drugs, and she was punished for very, very small misdemeanors, including threats that he would give should she wanted to run away or not abide by his rules, including killing her family. She, however, managed to leave the accused on several occasions, but would every time return to the accused because the drug addiction, when she would be overcome with desire to take drugs. The same with the second victim. The second victim, because of her particularly circumstances, you would remember she was the child, she was the person that got raped at 6 months and was already removed from her parental care by her father, and she ended up in the social welfare system already at age 6 months. She was also separated at age 12 from her siblings. They were taken to a different children's home than herself, and she ended up in a children's home where she was bullied. That very tragic childhood circumstances of this victim also caused her. And I think in the evidence it also transpired about 5 drug dealers and pimps that really exploited her and severely abused her physically. She fell in love with them. And if I remember correctly, she even described Easy Still as her boyfriend until when the investigation just commenced, she still thought Easy was her boyfriend. It was only later during the trial when she gave evidence that she actually understood the full impact of the abuse that Easy subjected her to. And then she explained to the court that and then by her language, the court could ascertain that she had an intense hatred for the accused for what he had put her through. And remember yesterday when I said Nalima that is the one thing I noticed with that child's evidence, as she never expressed any emotions throughout her evidence, which was odd because victims tend to express the emotions that this victim had expressed that is colored in blue. She was also she also had to witness how 2 women got killed in her presence. I see that is often, especially where Nigerian syndicates operate, where that is that victims report that they had to witness how other women got killed. I'm not sure whether the killing really happens or whether the women are just made to believe that this is what had happened. We had gone back to try to find bodies where the woman indicated the deceased woman was buried, and we've never been able to find bodies. So I'm not sure whether it really happens or not, but this is definitely a severe and very effective control mechanism. Here as well, the clinical psychologist testify on the behavior of the woman, because both women repeatedly left the trafficker but came back to Easy and got trafficked again and got sold on from one trafficker to the next, and the one woman, as I've explained, even fell in love with them. And the psychologist explained the nature and the circumstances under which this was happened. She testified that during the time that led to their rescue, they were subjected to witnessing and experiencing physical and sexual violence, threats, and encouragement of their addictions. These victims were therefore exposed to the typical mechanism used by traffickers to keep their victims in a web of trafficking that extend beyond the mere physical control to the expansive grip of psychological control. And I think that control is probably the most effective. The drug addiction kept him in constant debt to the trafficker, and so they were in debt bondage, basically. And the court held that the drug abuse, this case unmasked the sordid and sleazy world of drug abuse, prostitution, and exploitation, and that the accused exploited the addiction of the victims to the extent that he was in effective control of their lives. He also took advantage of their addiction by supplying the drugs to them, which held them in bondage, thus enabling him to profit from them, selling their bodies for his gain. Human trafficking, the court went further to say, human trafficking has to be understood as a criminal process rather than a criminal action. The elements referred to the definition are the result of a criminal strategy put in place by the perpetrators of this crime in order to secure the physical availability and presence of a victim by means of illicit means such as physical or psychological coercion, threat, use of force, abduction, abuse of power, or abuse of position of vulnerability in order to exploit the victim sexually and for other purposes. The perpetrators, again, the last paragraph on the previous slide actually more referred to the perpetration. I should have left it in this slide, but just see that the perpetration very often is the same. Both these cases refer to a syndicate, a criminal gang, committing criminal gang activities, all four of these victims were advertised for in-person sex on online websites, and in the easy case, the accused was also a religious person and advertised on, did cleansing ceremonies for the victims that had an impact on them. And yes, just what the magistrate said in the easy case, trafficking should no more be seen as a women's issue than slavery was a black issue, the Holocaust was a Jewish issue. These are humanitarian concerns transcending one race, gender, or creed. Thank you, colleagues.
Thank you very much, South Africa, and the rest of the panelists. I will give the floor now to Rahel Gershuni, just to wrap up with a few insights on the issues. We are ending the session at 12:50 on, as we've had to rework the program slightly. So Rahel, just be aware that we are stopping the session at 12:50. Over to you.
Yeah, okay. In brief, because the cases actually speak for themselves. But what I did want to note was that the representative from the Seychelles, do you hear me?
It's not very loud, so we're just trying to look into raising the volume so that we can hear you better.
Okay, so should I start over?
I think it's better now. Carry on.
Okay, so what I wanted to say was the presentation of the cases in many ways speaks for itself. But what I did want to note is that the representative from the Seychelles noted that in her in the Seychelles legislation, consent is irrelevant. Okay, I don't remember if it's irrelevant if means have been used or if it's simply irrelevant. But in any case, what I wanted to comment that whatever the legislation says, consent is always a live issue. It's always under the surface. And UNODC produced a very interesting issue paper on consent, in which the consultants traveled to 12 countries in order to explore the law and the practice. And they found that whatever the legislation said, consent was under the surface. We see it in all the cases of the case digest, okay? Even in the jurisdictions where it clearly states that it's irrelevant or not a defense. Why is this the case? This is the case because as criminal justice practitioners, we have an intuitive sense that consent matters very much. Why? Because there are crimes in which it makes the whole difference between a crime and a permitted action. One example is rape. On the whole, unless it's a minor, if there's consent, there is no rape. It's a permitted sexual act. Assault. If you touch me but I agree to it, it's not assault. excuse me, that's not correct. Grievous injury. Grievous injury. If you injure me, even if I consent, it's still the opposite. Sorry. Assault was what I wanted to say. If you agree to it, it's not an assault. So that's one reason. Another reason is actually philosophical. In the modern world, autonomy is one of the highest values. So we all believe under the surface that people have the right to make their own decisions, even if we think those decisions are not right, are bad decisions. And that's actually derives from the philosopher John Stuart Mill, who I think I actually quote in the case digest. Autonomy is a high value. The third reason is because usually in most cases of trafficking, the victim is a very important piece of evidence. I say this with the quotation marks. And therefore, as in rape cases, the victim's behavior becomes at issue. Her seeming consent or his seeming consent becomes an issue. It's extremely hard to avoid being influenced by a victim who says, this was my best alternative. I wanted to do it. Now, the truth is that many of the weaknesses which I mention in the case digest are actually boiled down to consent. One example is the failure to flee or seek help at the first opportunity. This is a weakness because we think that if the person was in such a terrible condition and had the opportunity to escape or to seek help, he would have done it. And if he didn't do it, either he's credible or he consented. Okay? So actually, even specific weaknesses are actually amount to questions of consent. Now, when I deal with exonerations which have been adjudicated, you will also see that many of the exonerations, under the surface, they see the victim as consenting. And that's so in cases where the victim sometimes initiates approaching the trafficker. We have several cases in the case digest where this is the case. The most interesting is the South African case of Fakudze, where the 13-year-old victim, abandoned by her mother, approached her stepfather who had previously molested her and and asked to accompany him to South Africa. I'm trying to think if there's anything else. There is something else that I wanted to say here. Why did the protocol take the trouble to allude to consent specifically? And this is the case also in most of your legislations. The reason was because the drafters were well aware that that was the prime defense claim. And if they allowed that to be a claim, then there would be massive exonerations. However, I asked myself, what is actually at the basis of the irrelevance of consent? And I think that there are actually two alternative ways of looking at it. The first way, the simple way, is trafficking usually, if it's not a minor, requires means. Now, the moment that there's a means, the consent is in question. We assume that there's some sort of flaw in the consent. Now, here I note that if you look at the protocol and if you look at your legislations, there is no requirement to prove that those means actually caused the victim to consent to the exploitation. Okay? We don't We don't need to prove that causal connection. It's an assumption. The moment that there are means, we assume that there is a flaw in the consent. So that's one way of looking at it. Another way of looking at it, which is very prevalent in the South American countries, is a bit different. And that is that in crimes like trafficking, which violate fundamental human values, consent does not matter. Society will not allow consent to matter. Why? Because, first of all, if such crimes are consented to, we suspect that the consent is not genuine. Example is murder. Okay, there was a case in Germany, I don't know if you've heard of it, it's really a horrible case, where there was an internet site for cannibals, people who eat each other. And on this site, a person, I think he was in his 40s, asked for somebody to agree that he eat him. And he received a response by an engineer named Brandis that he would like to be eaten. I will spare you the gory details. However, Brandis went to the home of this person, who plied him with alcohol, and ate him. Now, when he was charged with murder, he claimed to his defense the man consented. Not only did he consent, he wanted it. He answered my advertisement. He wanted to do this. He even, forgive me for saying this, ate part of himself at the beginning before he was completely dead. In any case, the court did not accept this defense claim. Why? Because human life is such a fundamental value that society will not allow consent to matter. And moreover, we suspect such consent. We suspect that it's not genuine. Now, actually, what I find useful, because this is the subject that has occupied me most for all the years that I've been in trafficking, which is around 20 years. Okay, this occupies me because it's crucial, and many cases fall on this basis. So what was I going to say about it? I have to recall myself. I don't remember what I was going to say. One moment, give me a moment to try to recall. Oh yes, so I came to the conclusion when I was doing this digest actually, that a useful way of approaching this question of consent is by a two-stage analysis. The first stage of the analysis is, was there consent? Now, some countries define consent. I think Botswana is one of them. And as Karina said, consent is uncoerced. And it assumes that you have the capacity to consent. So if there was deception, if there was a power gap, if there were means which were used, well, there probably was no consent at all. Okay? You have to look at it. Was there genuine consent? Was there voluntary consent? Was there deception involved? If so, it's not consent. Okay? If you weren't given all the information, it's not consent. Only if you come to the conclusion there was consent, then you go to the second stage of the analysis, which is your legislation. And most of your legislations say that consent is irrelevant if means exist. When you don't have such legislation, then you must go to your own legal traditions and laws about consent to see what is considered consent and what isn't. I think that I'm trying to think if there's something else. Fiona, can you remind me if there's something else that you think it would be good for me to say, or are there any questions? You tell me, Fiona.
Thank you very much, Rahel. I'm just going to look quickly at my notes and see if you've done a very good job at summarizing all the issues. We only have 8 minutes, so I don't know if there's any question from the floor while I'm trying to see if there's anything else that we need to add to what Rahel has said. We have Karina, she has a hand up, so I'll let Karina speak for now.
Yeah, I just want to add what Rahel had already stated, that you can't consent to your own assault unless, of course, there's a defense, like it's a boxing game or you went for an operation, because the principle of volenti, volenti non-fit injuria is applicable to South African law.
You know, the truth of the matter is, I guess legislations may differ on this, because in our legislation, assault you can agree to, grievous injury you can't agree to. And I always interpreted that to mean that grievous injury violates a fundamental value of bodily integrity, whereas assault is less. You see, so if there's grievous injury, naturally, we would all agree that there cannot be consent to grievous injury. As far as assault, in some jurisdictions, there can be consent to assault. Assault can be nothing more than a touch. You touched me when I didn't want it. But if I agree and you're my friend and you just touched me or you pushed me, you see boys all the time. I don't know if you see boys in South Africa. You see boys in Israel all the time playing with each other, pushing each other. And, you know, it's like the way they play. So I guess it depends on the jurisdiction as far as assault. And as far as sports, that's a whole real problem, as is sadomasochistic sexual contact, very complicated subjects. But the bottom line is that crimes which violate fundamental human values, usually in most jurisdictions, we don't allow consent to matter.
Thank you very much, Rahel. So I have nothing to add. I've just been looking at my notes. All the points that I made during the presentation have been ably covered by Rahel. Those fundamental human values are so important that you cannot allow a human being to consent to them. Karina just mentioned that, you know, we consent to operations, and some operations can be very, you know, they threaten life. And there's always that question. But obviously you can see that, you know, doctors swear an oath to do good, to preserve life, and they wouldn't undertake it if that wasn't an issue. So I think we can distinguish these issues and say, you know, where there is a fundamental threat to life and all these fundamental human rights, really nobody can be allowed to consent to being robbed of those rights. So I think, although we finished a little bit earlier, but I hope Rahel, Jeptem will agree that we deserve an early an early break. We finished 5 minutes earlier than we envisaged, so we can proceed to lunch. What time are we coming back? 2 o'clock. All right. Bon appétit. Not give our panel a big round of applause.
Okay, so now we
Good afternoon, delegates. Thank you so much for coming back and on time. We really appreciate it. Just before we go to the third session, I would like to just speak to you about a few administrative issues. One regarding the COVID test for those who would be departing, of course, because the meeting is ending tomorrow. We have organized to have a lab come here tomorrow morning to undertake the COVID tests so that by the time you depart on Friday and other, then you'd have your COVID tests ready. We are going to deal with the finances with the lab directly, so all you have to do is just show up and excuse me, take your samples. The lab will be here very early, from 8 a.m. To about 9:30 in the morning. We'll just have a schedule where, oh my word, excuse me, as I speak about COVID. So we'll have an agenda or rota for you to just come in and see, depending on when your flight comes. We'd like to give priority to the colleagues who are leaving very early on Friday morning. I think there's flights at 9 a.m. So if you're here early, maybe 8 a.m. or just before 8, the lab will be here to take your samples, but that will be sorted. So thank you very much for that. I hope that will be fine. In terms of, as well, finances, we were able to secure just a little money for any incidentals that you may have acquired for coming to this trip, just about $120, come about to 1,832 rand for each of you, just to cater for any challenges that you may have taken out of your pocket. This money will be, thankfully, it's going to be ready now. I had just spoken to a few colleagues. I was worried that it might not be ready there by tomorrow, but it's going to be here tomorrow, and we'll give it to you at the close of the meeting. What we request, which is required for us for administration, is just a copy of your boarding pass, because our colleagues who process it are in Vienna and they're not, we have to show them that really Cheptumo's in this meeting, otherwise we'll have to pay for it. So if you can please come with a copy of your boarding pass so that we can use that to pay you. I think that is correct, Obakeng? Obakeng, sitting at the back, is going to handle all the administrative issues. So please, if you have a challenge, she'll be more than happy to help you. So thank you very much. I'm very glad that we have here this afternoon the panel on from the Republic of Zimbabwe, the Kingdom of Eswatini, and the Republic of Namibia, to speak on their cases which had distinct issues that were related to victim behavior, and that created weaknesses or some weaknesses to the cases, and how the courts addressed them to be able to get a prosecution or other. So I would like to hand it over now to the panelists. Maybe we can begin by, we can go in alphabetical order. The Kingdom of Eswatini can begin, followed by the Republic of Namibia, and then the Republic of Zimbabwe, if that's fine by you. The Republic of Zimbabwe, is that fine? You're always coming in last. Would you like it to do the other way? Absolutely, that is fine. Let's change the system. Thank you. Over to you.
Good afternoon, everyone. And my name is Oscar Madume, and I'll present on weaknesses with victim behavior and how Zimbabwean courts are dealing with such weaknesses. And in doing so, I would deal with the case of Jessica Mahuni. This is a case that happened sometime in 2013, and by then Zimbabwe had no Trafficking in Persons Act, and we had to rely on provisions of the Criminal Law Codification and Reform Act. And the accused person was being charged of contravening Section 83, subsection A of that act, that is for procuring. Procuring is an offense that relates to prostitution or facilitation of sexual crimes. And in dealing with this case, I would break the presentation in 3 parts. Firstly, I would briefly talk about the overview of the case and the evidence laid, as well as the sentence. And lastly, I would confine myself to the weaknesses and how courts are addressing such. Jessica Mahoney is a Zimbabwean lady who was aged 62 by the time of commission of the offense. That was in sometime in 2013. The accused person appeared before a provincial magistrate court that is in Harare, and the allegations being that the accused person procured 2 victims, that is Yvette Tsapo, who was aged 20 by then, and Michelle Luigi, aged 23 by then. The accused jobbed the victims and they believed that they had secured employment as cross-borders, and they were taken to Angola. One of the victims had to fly, and the one had to go by road, and they all met with the accused person in Angola. When they were in Angola, the accused had a meeting with the 2 victims, and she indicated that this is Angola, it's no longer Zimbabwe, this is not Mugabe territory, and by then the late, may his soul rest in peace, Robert Gabriel Mugabe was the president of Zimbabwe, and she indicated that the victims were to comply with whatever instruction she was giving them. And initially, these 2 victims were employed for selling clothes. They had to spend the whole day selling the clothes, and after that, accused person would not offer them food. After some time being in Angola, the victims were then introduced to several male couples, and they were forced to indulge in sexual escapades, and the accused person would collect whatever these male clients were paying. And after that, there was another Zimbabwean person who, actually, when the accused person had a meeting with these 2 victims, it's fortunate that one of her relatives, that is a niece to the accused person, named Besim Tambiranwa, was also present. The victims later got an assistance from a good Samaritan, that is a Zimbabwean woman by the name Ms. Tigere, who took these accused person to Zimbabwean embassy. The accused person, when these victims arrived in Angola, she took their travel documents, their phones. They could not communicate. They could not travel back since their passports were taken by the accused person. And whatever instructions she was giving them, they had to comply because they had no means of even escaping. After being taken to the embassy of Zimbabwe in Angola, the victims were issued with the travel documents, and then they were repatriated to Zimbabwe, and the matter was reported, and the accused person was arrested. And when the accused person was arrested, when she appeared before the court, the accused person entered a plea of not guilty, and the trial ensued. The state had to rely on evidence of 3 witnesses, that is the 2 victims and Bestim Tambirana, who happens to be related to the accused person. The witnesses clearly indicated as to how they were taken to Angola, how they were treated in Angola, and what led them to escape and be issued with new travel documents. Fortunately, Bestim Tambirana, although she is related to the accused person, she testified satisfactorily for the state, and the evidence of the state was well corroborated, and the state managed to secure conviction. After the accused person was convicted, maybe before that, before conviction, the accused person during trial she had argued that no, this is a counter allegation by the victims. They'd stolen from her, but because of the evidence of these two witnesses who materially corroborated each other, and as well as Bestim Tambirano, who was related to the accused person, corroborating their story, and more so, when the accused person was arrested, the travel documents, the original travel documents of the victims were recovered from her residence. Such evidence was enough for the state to secure conviction, and the accused person was sentenced to 24 months imprisonment, and part of that sentence, that is 6 months, it was suspended on condition that the accused person in the period of 5 years, she was not to be convicted of any crime that involved prostitution or facilitating sexual crimes. It's unfortunate that when this matter was heard, the Trafficking in Person Act was not yet in place. So to see the reason why such a lenient sentence was imposed. If you look at the provisions of trafficking in persons section 3, subsection 2, that deals with a sentence, it calls for a minimum mandatory sentence of 10 years. And a minimum mandatory sentence of 10 years, and in cases where minors are being involved, to a period of imprisonment for life or any indefinite period imprisonment in the absence of special circumstances. And fortunately, the Zimbabwean jurisdiction had to benefit for the enactment of trafficking persons in 2014. Although this matter was finalized in 2014, we could not invoke the provisions of this section. The reason being that we could not retrospectively refer to this case, refer back to this case. Why? Because it was committed well before the enactment of the current act. And I would deal with the issue of weaknesses in victim behavior and how the courts in Zimbabwe are dealing with them. And Zimbabwean jurisdiction is not unique to other jurisdictions that that made presentations before at this seminar. You would note that part of the issues that has to deal with weaknesses in victim behavior range from inconsistent statements and falsehoods, memory gaps and distortions, seemingly implausible testimony, delayed complaints or reluctance to give evidence, among other issues. And in Zimbabwe, we would note that when the accused person took these victims to Angola, she threatened them. They really feared the accused person, and as such, to expose a victim in an open court for her to testify, obviously, some of the material evidence could not be said because they feared the accused person. And in Zimbabwe, in terms of Section 319B, capital letter, of the Criminal Procedure and Evidence Act, prosecution can make an application in terms of Section 319, capital letter D, of the same act for a victim of this nature to testify in camera. And that is another way how we assist victims with tendencies of being not able to testify in an open court. And also, we still regard the evidence of experts. Only what is required for the state is for us to lay a basis to show that the person we are calling is one qualified, he has a relevant experience, he or she can assist the court. We call expert evidence on areas where the court cannot make a valid judgment, we would need the expert to assist the court as to arrive at a just decision. In cases where there is no clear precedence on how to deal with arising issues, it's fortunate Zimbabwean jurisdiction allows us to refer to other jurisdictions to know how they are handling such issues. Although such decisions do not carry a binding authority, they are persuasive in nature, but they assist us in dealing with arising issues, especially on areas where I had indicated the weaknesses in victim testimony. Also, in terms of the Trafficking in Persons Act, the Zimbabwean jurisdiction had go a notch up, and in terms of that section, in terms of that act, Section 8, it creates provision for social services, for rehabilitation of victims, for assurance of victims. And this is the Zimbabwean story in as far as Jessica Mahuni case is concerned, and how we are dealing with issues relating to trafficking in persons. As I had indicated earlier, that the accused person was charged under the Criminal Law and Codification Reform Act of Zimbabwe, but you could see from the facts that they fit well into the Trafficking in Persons Act. It's only unfortunate that when this offense was identified, the act was not in place. Otherwise, we could have been telling the audience that the accused person was given 10 years, the minimum mandatory sentence. That is the Zimbabwean story. I thank you.
Thank you very much, Zimbabwe. Let's move on now to, did we agree on who is speaking next, or will we just come down the line? Okay, Namibia.
Thank you, Lady Justice. Good afternoon, colleagues. I know this is the graveyard shift, but please try to bear with us, ne? Okay. Yes, as indicated, I'm from Namibia, Soraya Pietrus. I'm also a prosecutor in the Office of the Prosecutor General. Since we are dealing with the issue of focusing on weaknesses in victim behavior and how our courts have addressed such issues, yesterday my colleague dealt with the Jonas matter, so for the sake of time, I will not repeat the merits of the case that has already been laid down. However, I will briefly look at what the digest has indicated to or highlighted as a weakness in that particular matter. At point, I believe it's 3.3.8.3, we see the heading, the naive or negligent victim. In this particular case, from one of the evidence of the witnesses, it came to light that, in fact, the accused person previously approached 3 ladies, this Helena, Maria, and another woman by the name of Monica, where she then indicated to them to come to, or to go to Okahanya to be girlfriends. And Monica testified as to that in court. So after they declined to take her up on that offer to be girlfriends, the victim, Maria, then later accepted when the accused again offered to bring her to Okahanya to come and work. The accused, the victim then accepted to go to Okahanya for work purposes. But the court did not necessarily see this as a weakness, or that, you know, the victim knew, or that she ought to have known that, in fact, it would have been for the purpose of her being a girlfriend. In fact, what the court looked at is, the court said that when the accused person did or saw that her initial plan to bring these women to Okahanya did not succeed as girlfriends, she then devised another method in order to trick them to eventually get to Okahanya, and then eventually to carry out her plan. So, in fact, the court rather looked at the evidence of this victim, which was then corroborated by the other witnesses as to how the accused person operated in order to bring women from Okahanya, from the north of Namibia to Okahanya in order for them to be exploited. Another issue that one can look at, which is often seen in a lot of our cases as a weakness, is that of a single witness. You know, when you are faced with single witness evidence, and I would just like to quote from the case itself as to how the court dealt with that issue. You can just quickly bear with me. The court stated that the complainant is a single witness in some material aspects. However, the court may convict on evidence of a single witness if certain requirements are reached. In the matter of State versus Salts, which is a South African matter, it was stated that the trial judge will weigh evidence, will consider its merits and demerits, and having done so, will decide whether it is trustworthy and whether, despite the fact that there are shortcomings or defects or contradictions in the testimony, is satisfied that the truth has been told. So, at the end of the day, after the court weighed up all the evidence, and again, we know that you cannot look at evidence in piecemeal. You have to look at it holistically. You have to take everything into consideration, the evidence presented by the state as well as that of the accused person, and to weigh it up against each other to get to a conclusion. And in this matter, as we've heard yesterday, the state was successful. Despite all of the things that happened, whether the witness was a naive witness or whether she was a single witness, the state was successful in its prosecution on the offenses of trafficking in persons as well as rape. This lady was convicted on 3 counts of trafficking as well as 3 counts of rape, and she was sentenced effectively to 28 years imprisonment in this particular matter. The other matter which one can say is the beginning of our trafficking prosecution in Namibia, and we are fortunate to have my colleague here, who was the person who did the first trafficking case. I want to start off with how dangerous a text message can end up. I will translate. Okay, it is in English, but it was written in Afrikaans. Hi, Chica. I'm having a friend. He's Alani. He's 29 years old. He's working at the Rossing mine. He's staying in Veneta. He will give you whatever you want if you meet with him tonight. He will give you $1,000. The word Lani, just for those who do not understand, it means white person. Okay. Now, this is the text message that started this case that I'm talking about, the Joanna Lucas case. This was the first trafficking case, as we've heard yesterday, which set the precedent sort of for how cases should be dealt with, and also the sentencing. In this particular matter, you will also hear about it tomorrow. Just a brief overview. It deals with the trafficking of 2 minor girls between the ages of 13 and 14 years of age. And the accused person in this matter was a lady. She was the one who, in fact, sent this text message to one of the victims, which we call D. And after some numerous interactions, D then eventually met up with her, and whereby she then introduced D to the man who would then later exploit her, which is Pretorius. And for my South African colleagues, we then, this case was also, Pretorius was also prosecuted. We successfully extradited him from the Republic of South Africa to Namibia for him to stand trial. So after meeting with Pretorius, D was engaging in sexual conduct, I think, more than 3 times with Pretorius. At that time, like I said, they were between the ages of 13 and 14. Eventually, D then introduced M to the accused person in this matter, Lucas, which then in turn introduced her again to Pretorius, but again under false pretenses. That is just a long story short. Ultimately, Lucas was charged at that time with trafficking of the two minor children, as well as the rape by, as we've heard yesterday, when you induce somebody to have sexual intercourse with another person, you can be charged with rape in terms of our Combating of Rape Act. Pretorius at that time was not prosecuted because he was not in the country. So in this particular matter, as we see in the digest, there are a few things that are highlighted as weaknesses in the behavior of the victims. One of them was the falsehood. When you read the case, you will see that both of the children, told lies to the school authorities regarding their whereabouts, as well as the fact that there were some inconsistencies in their statements. Let me first deal with the issue of the falsehood or the lies. When one looks at how the court in Namibia dealt with this particular matter, if we look at, I know you don't have the matter before you, but should you one day find the time to read this case, at paragraph 53, just give me a moment, I think it's 70. Yeah. The court stated that I wish to make a few observations concerning M. Unlike D, M was considered by the police and the principal to be remorseful about the fact that she committed the sexual act in the manner she did. She was candid about first lying to the school authorities and her parents regarding the liaison with the accused and Pretorius. She, however, later on owned up and admitted to having sex with an elderly white man in Veneta. I found nothing in either her demeanor, the account she gave of how the accused led her to Pretorius, and what Pretorius did to her to conclude that she was untruthful and had a motive to falsely implicate the accused. So at the end of the day, and we also see that in the digest, that even though initially in the beginning stages of this matter, during the investigation, the victims of trafficking, I actually don't want to call them victims, I want to call them survivors. They initially told lies, but later when they realized the intensity of the issue at hand, their stories corroborated each other, it became logical, and they stuck to their stories. The other issue that the court also looked at was the inconsistencies that was highlighted during the trial between the evidence of the two survivors. And the court indicated that if you look at paragraph 80, that insofar as I made no reference to such evidence, it is because I did not find anything in it which materially exculpates the accused or materially undermines the state's case against the accused. Such inconsistencies as there are in the testimonies of the two complainants, in my view, are not material and do not detract from the veracity of the complainant's accounts, which implicate the accused in the commission of the offense. I find their accounts corroborated by the accused proven lies. So in fact, the court did not only look at the inconsistencies, but again, took a holistic view of all the evidence presented, both by the state as well as by the accused person in this particular matter. I think I've been shown the 2 minutes, but I think that is as far as I will take this one for now. For any further, we can meet afterwards.
Thank you very much, Namibia. I actually added 2 extra minutes for everybody, so.
You see, I even went over.
Indeed. Let's hear from Eswatini.
Good afternoon, colleagues. We'll also be focusing on the weakness in the victim's behavior and how the courts address it. Fortunately, in our case, we're dealing with the case that we spoke about, we discussed earlier before lunch. In our case, the court did not exonerate the accused person on the basis that the court examined the totality of the evidence, and as such, it was able to gauge the victim's situation and vulnerability. When it came to the reasons for sentencing, clearly the court noted that the victims in their evidence felt that there was no need for them to report what was happening to them, since clearly the family members, the community members, and to some extent, the police knew what was going on in that family. But due to the status of the accused person, no one dared to approach him or confront him on these things, such that the court noted that the evidence of the girls was not shaken in any way by the accused person through cross-examination. We noted that when the court issued the reasons for judgment and sentence, it stated that the evidence of those victims was crisp and to the point. It's that in the essence that the girls were able to tell their father in the face of all that he had made them to do or undergo. And after he had unsuspectingly fetched them from the parents and from where they were staying, this girl still went back to him. I remember I said that earlier, one of the girls left the home, got married, was threatened by failure or having problems, and indeed that happened. Instead of going to any other place, she chose to go back home to the father where she was being abused. That would show the gravity or the extent of how the father had power over those children, such that they were afraid of him. It was clear beyond doubt that the victims, according to the court, were telling the truth as they gave all the graphic accounts of the sexual intercourse sessions that they could remember. Remember, it has been going on for years. And clearly, the court noted that those children couldn't have fabricated any of their evidence against their father. The court also noted that in defense, the accused person failed to dispute any of the narrated graphic events that took place. And unfortunately, the position of our law is clear that a bad denial of an offense or crime does not amount to a defense in terms of our criminal law. So in essence, the accused person had no patent defense to any of the offenses that were charged against him. And worthy of note was that the accused person was, according to the court, when they were looking at his demeanor, he was flabbergasted and at the audaciousness of the victims in the open court as how they related or narrated the events that took place to with them. In as much as it had been going on for a very long time. And the court noted that that was why even the accused person failed to dispute this evidence. It was also noted that there has been largely abuse of power by the accused person and the abuse of the position of vulnerability of the victims and the daughters who were his biological daughter whose mothers were deceased and the niece whose parents had been deceased. So that the court took into consideration that he has been abusing victims who are not only vulnerable but were also orphans. So that worked in the Crown's favor. And the court also noted that the accused person had exploited his status of loco parentis towards the victims to satisfy his sexual cravings. And with the Trafficking Act, the court stated that in its preamble, it wants the court to make sure that the protection and support of trafficked persons and anything that happens to people who are trafficked should be of paramount interest in our courts. Therefore, in addition to the charges of rape and the SODV charges that were preferred against him, the court took with seriousness the charges of trafficking that were preferred against. In as much as the setting one would only think that perhaps the rape and the SODV were sufficient, the Crown or the prosecution, in terms of taking other laws and putting them together in this charge, the court really commended that, in that as the prosecution, we shouldn't just look at one particular aspect of an offense, but use the bag of laws that we have to charge these accused persons, so that in as much, even if you go to 100 counts, as long as there is law that protects or guides us towards that particular charge, we should go for it, and it will be up to the court to decide on whether or not to convict that particular person on those other charges that have been meted out to have been preferred against the accused person. So in this particular case, the weaknesses of the victims did not work against them. Instead, the court took note that those children were under pressure or under a situation wherein they couldn't have reported this matter, or anyone in the community could have helped them report the matter finally to the police and have it taken to court. I think that is all from us.
Thank you. Thank you very much, Eswatini. At this point, I think maybe what I will do is ask the next panel to come up, and then we can have a wrap-up of both sessions. That way, maybe we will save time. But let's give them a round of applause for the preparation. So if Seychelles, Zimbabwe, and Eswatini could come back, and Angola. Oh, where? We will probably have South Africa join us online, so I'll just ask tech support to see if we can start connecting with South Africa online. And since there are quite a number of speakers, this time I will be very strict with the time allocation. So please make sure that you look up from time to time so that I can give you guidance as to how much time you have. Okay, I guess we will finish with South Africa since we need to connect to them. So let's start with Seychelles. Is Seychelles back? Are you ready to start?
Sorry, 1 second.
So South Africa is already online, so we'll start with South Africa now. If we could move to the Zoom. So you have 10 minutes, South Africa. Please go ahead.
Val, maybe you can start speaking. You're the one on the floor virtually. Val for South Africa.
Okay, thank you. I'm just going to quickly share a screen here. Can you all see that?
Not yet, but we're working on it.
Okay, I'm screen sharing.
Okay, we can see it now.
Okay, perfect, perfect. Okay, so hi everyone, good to be here. If I do break off because the internet connection is a little unstable, I'm sure Karina will take over. But at the last workshop that I attended, which was in Namibia, it was a judicial forum, I discussed this particular case, State versus Ye, which is a trafficking case where forced labor is involved. And basically it involves the accused, who are two Chinese nationals, accused 1 and 2, and accused 3 is a Swazi national. We had 2 previous accused. They pleaded guilty to immigration offenses and they've been finalized. So very quickly, the facts of the case are that there were a number of persons from Swaziland and Lesotho and South Africa that were recruited by either accused 1, 2, or 3 who were working together. What would happen is accused number 3, who was actually a Swazi citizen, would go to Swaziland, and literally at the border of Swaziland and South Africa, there would be a lot of unemployed people waiting. She would make them an offer of employment to work at a factory, a clothing factory in Newcastle, which was quite close to the border. And many of these people accepted because they were, you know, in dire financial situations. They were very poor, desperate economic situations. So they just wanted to work. Some of them would, she promised them that they would earn well and that food, transport, and accommodation would be provided. So all these persons accepted. When they got to the border, what would happen was some of those who did not have valid passports were told to run through the bushes to avoid the soldiers at the border. Those that did have valid passports were fetched from the border by either accused 1 or 2. Those that ran illegally through the bushes would thereafter be picked up at a point by accused 1, and then they all would be transported to the factory late at night. So this is just a quick picture of the factory. It was one of many in that particular area. Okay, so when they arrived at the factory, they had to basically buy a sponge mattress from the accused. Some of them started working, and they eventually discovered that they had to pay for all the transport and accommodation, even the sponge mattress and blankets, which they were not told about. When they arrived at the factory, there were no specific discussions between the accused as to any kind of, you know, official employment contract which sets out wages, conditions of work, benefits, leave, sick leave, and so on. Okay, so what would happen? The victims literally started working almost immediately upon arrival, and in terms of pay, they were paid according to how many garments they sold. So one person would sew, like, say, 1,000 sleeves. One person would sew 1,000 necklines. And for each one of those pieces of items of clothing that they sold, they either got paid 5 cents or 10 cents, which was a very, very meager amount of money. In terms of their working hours, as you can see, they were abnormal hours, 7 a.m. to 5 p.m., and then they would work again from 6 p.m. to 10 p.m. So they just had a few hours of sleep and literally a 1-hour break from 5 to 6 in the evening to bath and cook and so on. Many of the workers worked without pay, and they even worked when they were sick and exhausted. An interesting thing was accused number 2, the female accused, would shout a lot at the victims, even though she could not speak English properly, you know. So it was interesting what the shouting was all about. I'm at the stage of this case where I have closed the state's case. The defense are making an application for the discharge of all the accused and all the charges. So at the moment, I'm busy preparing heads of argument. And in my prep, I'm using a lot of the cases from the case digest that was distributed by UNODC. So one of the cases, just to address, you know, shouting. I mean, we think that, okay, if someone shouts at you, your boss shouts at you, it could be acceptable. But an interesting case was Pipkins, where the court noted that, you know, there was verbal abuse by the defendants, which it termed mentally sapping. So I just thought I'll just slot that case in there to show you that I'm going to use a lot of little things to, and I know UNODC in the case digest, they talk about the mosaic of evidence. So I'm going to take this and use it as one piece of the puzzle to paint a whole picture to the court. We found, as I said earlier on, communication was very challenging. In fact, they used sign language to communicate. The languages involved was mainly Chinese between the accused, a smattering of English, and then the workers were, you know, spoke Sotho or Siswati. And the case I'm going to rely on there to show the court about the language issue was that in Weitang, one of the factors that the court looked at was that the victims knew very little or no English. And the court looked at that as a factor that established the defendant having control over the women. So I've just slotted in these cases just to show you how I'm going to deal with those issues when I get to my heads of argument. So some factors that I also looked at that restricted the freedom of the workers were, you know, could they come and go freely and so on. So this is a picture of the entry and exit. This big metal garage here was permanently locked. So this little doorway that you see is the only entry and exit for all the workers. And you can see there was a gate here, and there was also a security guard at the gate. That gate was kept locked all the time, right? The workers did not have access to keys. They were not allowed to go outside. And even when they were allowed to go outside, as you can see, they had a curfew. They could only go out on Friday and Saturdays between certain hours. If they came after the curfew, they were then locked out of the factory and their accommodation. So basically, they were compelled to be on time as they had no other place to stay. Also, the employers, when the workers did go out, they would make sure that the workers kept their personal items inside the factory. And the case law does say that this can, in a sense, restrict a person's freedom to leave. Because sometimes a person's belongings are their worldly goods, you know, and especially when they're very poor, the little that they have means a lot to them. So the employers kept them in a state of scarcity as regards money. They made a lot of deductions. There were fines if they, you know, came back late. And so there are very few alternatives to living and working in the factory. So another important factor that came out in this case, that there was an acute lack of leisure time of the workers. They didn't have time to just sit and relax, no free time. The only free time they had was that 1 hour from 5 to 6 in the evening, where they just went and bathed and cooked, and then they would come back to work. Many of them were illegal in the country. Those that did have visitors' visas just only allowed them to visit, did not allow them to work. So many of them were working there illegally, and basically the accused were harboring, accommodating, employing illegal foreigners in South Africa, right? The recruiter reinforced the boss's connection. The boss was accused one. He knew a lot of policemen. So I'm going to argue that they were veiled threats of arrest due to their illegal status. They were told, you know, if you leave, just be careful because there's a lot of police outside. So, you know, they were sort of brainwashed into believing that. Some workers were allowed to go back home and they did return to the factory, and the defense in cross-examination put it to many of the workers, well, why did you come back to such horrific conditions, instead of complaining? And most of them said they were very poor and they had no other work. They just needed an income, no matter how small it was, to support their families. They lived in illegally constructed quarters behind the factory. 16 persons shared one room, and they all slept there, right? There was a passage in the toilet, and in that passage, they would cook. And also in that passage was the toilet, which had no door, so anyone could see what you were doing, right? They were exposed to very unhygienic living and working conditions as well. And there was also raw sewage that flowed into the passage where they cooked and slept. In fact, what the owner did was he took the emergency hose pipe, pushed it into the sewer system, which was actually under one of the beds in one of the rooms, and he would just sort of flush it out every now and then when it would get clogged. So the environment they worked in was very hot as well. He had an air conditioner, but he didn't switch it on because he said it was too expensive. And when they did complain about the conditions, they were told, well, you can go and get another job. So there's a lot of subtle coercion, veil, if you want to call it veil threats as well. Again, due to desperation for work, they did not leave. One of the females was assaulted when she tried to leave, and she was forcibly brought back to the premises. However, she managed to escape, reported the matter to the police, and this is how the whole case came to light. So this is just some of the conditions over here that in the factory. You can see this thing here is a big engine part. There's tires, so it's very dangerous. People can get injured and so on there. You can see our windows, there's no fans. Okay, this is the inside as well, bundles and bundles of clothing, typical. I don't know if this is your typical clothing factory, but this is what my case looked like. Again, you can see a close-up of this is after the police secured the premises, lots of tires. I don't know what he was fixing in the middle of the floor there. This is actually accused one, yeah, and that's his wife. Okay, so this is the sleeping quarters. You can see that they were just given a piece of board. There's some metal framework, and they were all sort of stuffed like sardines in this place. No privacy, really. These little buckets, they used to bath as well. Okay, so those were my role plays. I won't go through it due to time. So in arguing this case, I need to convince the court that this is a trafficking case, and I need to prove the act, the means, and the purpose in terms of South African law. So these are the aspects of the act, means, and purpose that I'm going to argue exists in my particular case. My challenge is going to be to convince the court that this is a forced labor case. It's a case of servitude or slavery, or a practice similar to slavery. I'm not going to go through the definitions in detail, but these are the definitions that appear in our act. Servitude, it basically involves threats of harm. So what I've put here in red is where I can say, from my case, I can prove there were threats of arrest, there were financial restrictions, there were freedom restrictions. There had to be a scheme that the person would believe that if they didn't perform the services, they would suffer some harm. I'm going to argue that, that there was actual or potential harm, which I'm going to try and convince the court that I've proved through the living and working conditions by the accused contravening basic conditions of employment. Forced labor, these are the elements I have to prove. There has to be consent. Without the consent of that person, and then either through threats or perceived threats, force, or intimidation. The issue of consent that I'm going to look at is, I'm going to argue, there's no definition of consent in the TIP Act, but I'm going to argue to the court that there was no real and informed consent of the person. I am able to prove that there were threats or perceived threats of harm. There was a bit of use of force, and I'm going to look at intimidation in the forms of coercion or physical restraint of certain victims. And the fact that they were locked up in the factory, I'm going to try and say or argue to the court that was sort of a form of physical restraint. So consent is going to be challenging because the defense are actually saying to the court, but no, these people came here. They knew, they worked here willingly, they agreed to work, and so on. So that's his defense. And my argument to the court is going to be that the accused did not make the victims fully aware of all the terms and conditions of the job offer in order for them to freely and fully consent to those things. And real consent is only possible and legally recognizable where all the relevant factors are known and the person is free to consent. So in my case, I'm going to argue that this did not happen. They were promised the world by the recruiter. There was a misrepresentation of the true facts, and there was no consent by the victims. This is one of the cases I'm going to include in my heads of argument, the Malawian case in Bandawe, where the accused did not divulge crucial information to the victims, and they didn't even disclose the final destination of the victims or who would employ them. And the court noted that in doing so, they denied the victims vital information necessary to form decisions. So I'm relying on a lot of cases from the case digest, and it's really been so helpful as well to me. An interesting one for me is going to be slavery. Am I able to convince the court that this is a case of slavery? In terms of our definition, it means reducing a person by any means to a state of submitting to the control of another person, as if that other person were the owner of that person. A little bit complicated, but simply, can I, as the state, show that the victims were made to submit to the control of the accused? And I've put yes here. I'm going to try my best to convince the court that, you know, just in terms of the whole manner in which he operated this factory and the conditions they lived under and so on, he controlled them. They could do nothing without his permission. Did the accused control every or most aspect of that victim's life while at the factory? Yes. And I think in terms of the conditions under which they lived and so on, I'm quietly confident that I'm able to show the court that. Yeah, the question is how I'm going to show the court that. So I'm also going to show the court that the accused failed to comply with each and every legal rule and regulation for running his business. He failed to comply with basic conditions of employment within the clothing sector. I actually called someone from the bargaining council. It's a body that regulates everything to do with the clothing sector, and that witness basically said that this accused, with impunity, breached every single rule and regulation that was required of running a business like this. The challenge I have, however, in my case is that the magistrate, I think, possibly is viewing this as a simple case of labor contraventions, and that is the defense's argument. This is not a trafficking case. This is just a case where the accused and the worker, there's been some sort of disagreements between them, and it's got to do with labor laws. And so my job is to basically convince the court that this is not just a simple labor case, it's a trafficking case for the purpose of exploitation in the form of forced labor, servitude, or slavery. So, these conditions where he controlled the workers financially through illegal deductions on their wages, restricting their movements, curfews, using veiled threats, his
I'm sorry to
blatant
interrupt, Val.
refusal. Sorry?
I'm sorry to interrupt. I just wanted you to be aware of the time. You're already at least 10 minutes over your slotted time.
Okay, I'm wrapping up. I'm wrapping up.
Thank you.
Give me 1 minute. Yeah. So basically, yeah, I'm almost at the end. So the challenge here is to convince the court that this is not a simple labor case, but it is a trafficking case. And I would appreciate any input from any of you guys to assist me in this matter. So that's it from me. Thanks.
Thank you very much. I'm really sorry that I had to interrupt you.
No problem.
We
No
will,
problem.
we will, I hope, have an opportunity to engage with you again on this very important practical case that's still ongoing, unlike the others that are finished. So we move on now. Who is next? Do we now go to Angola?
Boa tarde a todos. Portanto, nós trouxemos para esta sala, para esta sessão, um caso que é bastante recente. O caso ainda se encontra na fase de instrução preparatória, portanto, não chegou ao tribunal ainda. Mas nós optamos por este caso porque é um caso que achamos bastante ricos naquilo que concerne a elementos que tipificam o crime de tráfico de seres humanos na vertente de exploração laboral. Como disse, o caso foi denunciado no ano passado, em 2021, foi uma denúncia anônima recebida pela polícia e o conteúdo desta denúncia é de que existia uma casa onde dois casais exploravam laboralmente e sexualmente várias crianças provenientes da Nigéria. Ao verificarmos, ao irmos mais a fundo na investigação, não confirmamos a questão, não ficou provada a questão da exploração sexual, mas apenas a questão da exploração laboral das crianças. Os fatos despoletavam-se da seguinte forma. Uma senhora nigeriana de nome Rafiato vivia já em Angola há vários anos e contactava pessoas da sua própria comunidade na Nigéria e alguns parentes, solicitando crianças para trabalhar, na verdade para estudar em Angola. Ela dizia que as crianças iriam estudar em Angola e que ela pagaria aos tutores, aos pais ou respectivos tutores destas crianças, a quantia de $150 mensais. Esta senhora fazia então a ligação das famílias nestas comunidades da Nigéria que, diga-se de passagem, que eram comunidades bastante carenciadas, e muitas dessas famílias realmente aceitavam e mandavam os seus filhos ou parentes nestas condições. Ao chegar em Angola, as raparigas eram colocadas a trabalhar no mercado informal, na capital de Luanda. Diga-se de passagem que é um dos maiores mercados da capital angolana. E foram encontradas nestas circunstâncias 8 vítimas. Não foi possível saber muito sobre as condições anteriores ao que elas viviam antes de serem transportadas para Angola. Contudo, deu para perceber, sim, que vinham de famílias bastante carenciadas e algumas delas até mostravam que preferiam estar em Angola a fazer aquele trabalho do que voltar para a Nigéria para as condições em que viviam anteriormente. Foram acusados no processo ou constituídos arguidos os cidadãos ao Aconate e ao Roberto, que é um casal portanto, da Costa do Marfim, são costa-marfinenses, que acolhiam as crianças em casa, exploravam, mandados ao mercado informal, praticar os atos de comércios que já havíamos referido aqui. Uma outra senhora, chamada Mutiate Balagum, recebia as crianças provenientes da Nigéria por serem parentes, alegadamente por serem parentes ou ter laço de parentesco com essas crianças, e entregava ao casal acima referido. Após a detenção dos arguidos, foram submetidos a interrogatório pelo magistrado do Ministério Público e, em sua defesa, a arguida Mutiate Balogum disse que as crianças viviam com ela por terem laços de parentescos, e os coarguidos, ao Aconate e ao Roberto, disseram que vivem no mesmo quintal no mesmo quintal onde vive a primeira arguida, mas em casas diferentes, e que nada tinham a ver com as vítimas. As vítimas alegavam ter chegado a Luanda saindo da Nigéria, passando pela Costa do Marfim, República do Congo, e que não tinham quaisquer documentos. Entretanto, a investigação revelou que as mesmas chegaram a Angola por via aérea e que os seus documentos haviam sido guardados pelos arguidos. As mesmas foram para Angola com consentimento dos seus progenitores e respectivos tutores, mediante promessas de que iriam estudar e que os pais receberiam $150 mensais, que já referimos, e que acabaram, na verdade, por trabalhar de forma ilegal no mercado informal. As vítimas trabalhavam sem recebimento de salários. Foi-lhes dito que receberiam o dinheiro pelo trabalho desempenhado quando regressassem à sua terra natal, ao completarem 24 ou 25 anos, e que a esta altura também contrairiam matrimônio que seria pago pelos acusados. Ao serem ouvidas em declarações, as vítimas fizeram parecer que não estavam a ser exploradas e que viviam como uma família feliz sob tutela do casal de acusados, ao Aconate e ao Roberto, pois eram na verdade bem tratadas, tinham amigos, podiam sair de casa sempre que quisessem e, mais uma vez, preferiam viver em Angola naquelas condições do que regressarem à sua terra natal. E, mais uma vez, no decorrer da investigação, revelou-se que os fatos não eram assim como elas faziam crer a princípio. Verificamos também que os nomes que elas deram às autoridades e às idades eram idades falsas, pois os acusados, após receberem os seus documentos, trocaram os seus nomes ou deram outros nomes e outras idades, e foi com esses nomes falsos e idades falsas que elas apresentaram-se perante as autoridades judiciais e do Ministério Público. O órgão, a Comissão Interministerial, que é o órgão do governo angolano que cuida e acompanha os casos de tráfico de seres humanos, entrou em contato com a Agência Nacional para a Proibição do Tráfico de Seres Humanos da Nigéria e depois de ter estabelecido contato com as vítimas, portanto, esta Agência Nacional entrou em contato com as vítimas via Zoom, onde tiveram uma conversa muito demorada e foi produzido um relatório onde consta que elas confessaram que não tiveram contato com os pais que vivem na Nigéria ou não tinham contato, porque algumas disseram que tiveram contato com os pais apenas ao sair da Nigéria e ao chegar em Angola. Disseram também que não frequentavam nenhum estabelecimento escolar oficial e apenas estudavam árabe em casa, mostrando muita tristeza por este facto, pois elas realmente gostariam de aprender a ler e escrever corretamente. Consta também do relatório que as meninas não tinham liberdade de locomoção e não podiam usar telefones, portanto, tinham a liberdade de locomoção restringida pelos acusados, não tinham telefones para poderem falar com amigos ou com seus pais, ao contrário do que elas disseram às autoridades do Ministério Público ao serem ouvidas. Passarei agora a palavra ao meu colega, que vai fazer um breve enquadramento legal de acordo com o ordenamento jurídico angolano.
Muito obrigado. E vai ser mesmo de forma rápida, porque temos de aproveitar melhor os 10 minutos a que temos direito. Apenas duas notas antes mesmo de concluirmos esse nosso caso. A primeira tem que ver com as questões jurídicas relevantes, ou seja, fazermos um enquadramento desses factos no nosso ordenamento jurídico. E aqui importa dizer que, quando foram submetidos a interrogatório, os arguidos, o magistrado aplicou-os, ou seja, indiciou-os na prática de um crime de tráfico de pessoas, que está previsto e punível no artigo 178 do Código Penal angolano. Na altura, o magistrado ficou apenas por esse crime. Entretanto, como dizia o meu colega, este caso ainda se encontra em instrução preparatória. Tudo indica que, para além do crime de tráfico de pessoas, poderemos também ter aqui um crime de associação criminosa, que está previsto no nosso artigo 296 do Código Penal, e auxílio à imigração ilegal, que podemos encontrar consagrado no artigo 103, número 2, a linha B, da nossa Lei 1319 de 23 de maio, que versa sobre o regime jurídico dos cidadãos estrangeiros na República de Angola. Na altura em que eles foram submetidos a interrogatório, o magistrado aplicou medidas de coação pessoal, como é normal. A dois deles, no caso o casal, aplicou-lhes o termo de identidade de residência e obrigação de apresentação periódica às autoridades, e a arguida Mutiate Balogun, a medida mais grave, que é a de prisão preventiva. Nessa altura em que vos falamos, ela ainda se encontra nesta condição. O nosso ordenamento, relativamente a esses tipos legais de crime que nos referimos, para o crime de tráfico de pessoas, a moldura penal abstratamente aplicável vai de 4 a 10 anos de prisão. Para o crime de associação criminosa, de 1 a 8, podendo o cabecilha do grupo ser condenado até 10 anos de prisão. E o crime de auxílio à imigração ilegal pode, ou seja, enquadra-se numa moldura que vai dos 3 aos 7 anos. Uma segunda nota tem que ver com a posição que foi dada às vítimas, ou seja, em que se encontram as vítimas, do ponto de vista de proteção das mesmas. Importa salientar aqui que, das 6 vítimas, 3 delas são menores e 3 delas já são adultas. E então, elas nessa altura encontram-se já sob responsabilidade do Estado angolano, na medida em que essas menores foram colocadas num centro de acolhimento e as maiores foram colocadas num centro de detenção de estrangeiros ilegais. Contudo, por causa do estatuto da vítima, serão brevemente transferidas para uma casa de acolhimento para adultos, pois até agora não se verificou, da parte das mesmas, vontade ou dos seus progenitores para voltarem ao seu país de origem. E, neste sentido, estão em curso diligências atinentes à regularização desta situação migratória das vítimas. E, para terminar mesmo, eu vou devolver a palavra ao meu colega.
Obrigado. Tanto só em termos de conclusão, dizer que foi possível depois, através da Embaixada, obter a verdadeira identidade das vítimas, foram enviados as certidões de nascimento, as verdadeiras certidões de nascimento das mesmas e juntou-se ao processo e fez-se a respectiva tradução. Dizer que este caso despolitou-se devido à extrema condição de pobreza em que as vítimas viviam na Nigéria, mais uma vez, e mais uma vez reforçar que escolhemos este caso por ter elementos muito fortes e são variadíssimos elementos relativos ao tráfico de seres humanos que vimos aqui presente e que estão também ligados a todas as questões que estudamos no compêndio que nos foi enviado pela ANDOC, como, por exemplo, podemos referir os casos de situações de vulnerabilidade, como o estatuto de imigrantes ilegais, a idade, o género, a alteração da própria identidade, o impedimento de frequência do estabelecimento escolar. Referir também que se trata de um crime que foi cometido pelo uso de engano, houve restrição da liberdade das vítimas mediante constante supervisão e criação de dependência financeira. Verificamos também aqui a questão do isolamento social pelo impedimento do uso do telefone. É tudo. Muito obrigado.
Thank you very much, Angola. So we now have 2 ongoing cases, South Africa and Angola. Can I ask who's next? Is it Seychelles? All right, please proceed.
Good afternoon, everyone. So our issues are about the alarm case that we explained earlier. One of the issues when considering the alarm case was that there was an absence of complaint. With the alarm case, it was a tip-off that led to the investigation by the immigration, the tip-off of another health officer. Without that, we would not be able to have started the investigation in the matter, which eventually led to the court case. Okay? So the absence of complaints is not only because there is a lack of complaint. We see that in the same case, there was the fear of deportation. So the victims themselves would not want to complain when they know that if they complain, they will be deported back to Bangladesh. And the fact that most of them were sole breadwinners of the family, they could not risk to be deported because the families were counting on them to bring in the money. They had reached Seychelles either through a loan or they had mortgaged their property for that matter. So they could not really risk it. They had to just abide to it and not complain to the authorities. With that, we also see that apart from alarm case, other circumstances as highlighted in the case from Angola, there is this lack of awareness of the victims that they are actually victims. they tend to think that, okay, everything is normal, the condition is not as worse as back at home, so we can deal with this, we can survive this. So they will not report the matter to the authorities. So this leads to the fact that at the end of the day, the immigration or the Department of Employment does not obtain a lot of complaints unless there is a TPO. Another issue is the fact that there is this communication problem with the victims. As Seychelles, we have 3 languages. We speak Creole, French, and English as much I can say fluently. I think my colleague would agree on that. But however, the victims, most of them will come from Asian countries that we do not really understand or be able to speak that language. What tends to happen is that we tend to communicate via a broken English, I can say. They can understand little by little, and then they can express it even with sign languages with their hands. They tend to explain this. If this is wrong, they'll tend to point to this. So this is how we communicate. But this is not an efficient or effective way to understand what is going on. So they cannot properly address themselves to the officers or even in court for that matter. Okay, so in light of that problem, what happens is we now need to get translators. Okay, now, as pointed earlier, we are a small island state, so resources such as translators is not readily at our disposal. It is quite expensive, may I say, to have that, and we do work as a budget, given each department has a budget, so we need to make sure that the money is available to afford these translators. But once that we have achieved the services of these translators, we can now properly communicate and understand the circumstances in which they are in. So this is just for the cases before the matter is brought to court. We also see, in regards to that, the fact that most of our issues, although there is trafficking person for children, a lot of it is for labor in the sense of construction workers. So this means that the officers of the employment or immigration need to constantly be visiting sites of construction to properly know whether or not there is exploitation of the laborers. However, there is only a small amount of the officers and so many construction sites, so they cannot properly monitor the sites, and if the victims themselves do not come forth, they will not be able to do anything. So with that, then we have the issue of the fact that the matter arrives to court, and then we need the fact that the victims need to testify. When the matter is before court, we have found that sometimes the victims themselves do not want to testify now. They refuse. All they want is to go home or to be left alone. They want to work for another contractor. So what can you do? You cannot force them, because that would be doing the same thing as the one that led them to Seychelles. So what we tend to do as a solution is we let them depone first, so that way they don't have to testify again unless requested. So we try to make sure that they are the first one to provide with their evidence in court. Also, we have found that although there is some level of victim protection under the Act itself, in particular this case of Alam, what happened to the victim was that they were placed in another accommodation so that the accused could not intimidate them. But we need to be aware that sometimes the accused may have resources, and just moving them to another location is not enough. Okay, so on that we would like to improve. Having said that, we have issues such as an absence of complaints or the lack of resources. We are trying to fill in the gap. For example, we see that the authorities, especially in this case of Alam, they did a great work. They worked collectively together. The immigrations, once they received the tip-off, they communicated with the employment department. Employment then ensured that the police was kept in the loop, and then we saw that when another officer or health officer saw the matter, it was reported. So it came back to a full circle, and even the prosecutors, everybody did a great work. So it was a full circle situation whereby in this Alam case, it was very successful. And we hope that in the future, when another case happens, we deal with it in this spectacular way. Also, with the alarm case, given that it was the first case in which it was the law was applied, it has now paved the way for other cases. A recent case in 2019 is the Republic versus Abwas. This is a case whereby a national, Seshilwar himself, was exploiting the Bangladeshi workers. And the Bangladeshi workers, the victims themselves, took it upon themselves to actually bring the case to the employment department. So you can see that there is that dare that Ms. Rachel stated, in which that they now want to be protected. Also, we see that more and more, whenever workers are not being paid their salaries, which unfortunately has been happening a little bit frequently towards the laborers, they have instigated strikes. You will find them sitting at the building of the employment or the immigration, and then suddenly will be news. Said contractors are not paying the workers. So now there is this eye-opening for those that especially are coming from either Bangladeshi or India. They know, they will hear, because as we know, news travels fast these days. So with this, it has created a bit of solutions whereby we lacked the complaints, but there is still some that is coming in, so that we ensure that justice is made at the end of the day. Okay, thank you.
And if I may add, with the issue with the interpreter, we have to realize that most of these laborers, they come from lower socio-economic side of their community. Most of them have not had a formal education. So even sometimes you might find a good well-trained interpreter, translator. In proceedings, you might find difficulty, especially when you are in court. You might use certain legal jargons, but you try to simplify it. And sometimes it does not create the same effect when you're simplifying the wording in court. So this is one of the issues. And you might find we've had other times, like Indians or Bangladeshis, they might have other dialects, I may say, because from different regions. You might find one interpreter not being able to interpret for one or two of the other victims. So this creates another problem. And as my colleague rightly stated, we are a very small country. Sometimes even embassies will have limited amount of staff. They will not be able to assist. What they do is try to find other people in the country with the time and the resources to assist. So this is one of the main issues. Thank you.
Thank you very much, Seychelles. We now move on to, let's go to Eswatini.
Good afternoon, colleagues. I'm here to present on a case of labor exploitation, which took place in 2009. Oh no, in 2015. So I'm now citing the act. This is about a 19-year-old boy who was recruited in South Africa by Swaziman, who is the perpetrator. Yes, this young boy is from Lesotho. He's also not from South Africa. So when he was recruited, he was deceived that he was going to work in Mpumalanga, still here in South Africa, in one of the provinces closer to Eswatini. But then he was smuggled into Eswatini through illegal means or informal crossings, since he did not have formal documentation to cross over to Eswatini. So when he arrived in Eswatini, he was employed as a head boy to look after cattle, which belonged to the accused person. This boy was working under very not so good conditions. The working conditions, they were not favorable. He was sometimes made to go without food, and the house in which he was living in, it had cracks on the walls such that you could see through the house, you could see outside. And also the door to that house was not, it didn't have a lock, so he used a wire to lock the door of that house. He would go ask food from neighbors. He was promised a salary of 1,000 emalangeni, which is equivalent to 1,000 rands. But that money was paid to him once, and he was never again paid anything for the duration that he was working for the accused person. The accused person was eventually arrested by the police after investigations and tip-off from neighbors who saw this boy being exploited. The accused person was charged initially with 3 counts. One count of human trafficking, being that he unlawfully recruited, transported, and employed the said 19-year-old boy in Eswatini. And count 2 was that of smuggling, in that he did unlawfully arrange the illegal entry of the 19-year-old boy from South Africa to Eswatini. He was also charged with assault with intent to cause grievous bodily harm, since from the facts we got to know that at some point this boy was assaulted by the accused person and also threatened that he will take away his clothes if he tries to flee to his country. This matter was heard at the subordinate court in Shiselweni region, and when this matter came to court, the charge of assault GBH was scraped off because the court felt that the assault GBH was part of the exploitation which this boy was going through. And he was sentenced to 15 years on the first count of human trafficking, and also 15 years on the count of people smuggling. And these counts were made to run consecutively, which means he was supposed to serve 30 years. But then the accused person appealed to the High Court of Eswatini, and apparently the judge at the High Court felt that when the magistrate court sentenced the accused person, it did not take into account the triad which the court has to look at when sentencing an accused person, and reduced the sentences which were actually meted out by the magistrate court. For the trafficking case, he was then sentenced to 5 years imprisonment and 1 year was suspended. And on the smuggling case, he was sentenced to 4 years and also 1 year was suspended, and these sentences were made to run concurrently. Looking at the issues which we are supposed to look at in terms of this offense, being focusing on typical issues which arise in cases of trafficking for labor exploitation, we felt one of the issues is the issue of assault with intent to cause grievous bodily harm. The courts, they felt that the assault was part of the exploitation, so that offense was not looked at. Yet this boy was assaulted and also threatened that if he tries to flee back home, his clothes will be taken away from him. So this charge was not looked at as a separate charge from the trafficking charge. And also we looked at the issue of vulnerabilities. The accused person was an illegal immigrant in Eswatini. He didn't have proper documentation or legal documents for crossing into Eswatini. He was a very young person, a boy of 19 years old at the time, and he was also unfamiliar with the language since he was from Lesotho, so communication for him was very difficult. And also the culture of the place in which he was staying, the culture of Swaziland. He was not familiar with the culture, so communication for him was very difficult. There was no way he could go because of that. And also restrictions of freedom, which are also important in a case. He was restricted by his legal status. He didn't know where to go, and what if maybe he was also arrested for being in the country illegally. And there were no relatives of the boy in Eswatini, and also the language was also a barrier. And the isolation, as I've said, that he didn't know anyone, there was no one there, even the house he was staying in, it was really in a bad state. And also the lack of money. He was only paid once for all the time he was working there. And also the threats and by the accused person that if he tries to flee to his country, he will take away his clothes. Those also contribute to the restrictions which were put forward for him. And also the presence of the physical abuse, which was he was subjected to. I've spoken a lot about that. And also the non-payment of salary. From the digest, you could see that the non-payment is mentioned by the courts in the region as a relevant element in convictions, and it is also a relevant circumstance that when proved, it also acts as an aggravating factor to a case of labor exploitation. Thank you so much.
Thank you very much, Eswatini. We'll now move on to Zimbabwe.
Thank you. Good afternoon, ladies and gentlemen. My name is Netsan Shayabasa. I'm a prosecutor in Zimbabwe. I'm going to present on the issues arising in cases of trafficking for purposes of labor exploitation. And in my presentation, I'm going to focus on the case of the state versus an accused person named James Marodza. It's fortunate that I had the privilege of prosecuting the case. I was the one who prosecuted the case in 2018. This case involves a 30-year-old man who at that time was 30 years and was committed in 2016. This accused person operated an employment agency referred to as Employment Engine Global Services. It was a registered employment agency in terms of the Zimbabwean labor laws. He would flight adverts on national radio and the newspapers on the pretext that his employment agency was recruiting ladies to be employed as domestic workers in Kuwait. So many vulnerable women fell prey of his agency. They went and engaged his agency, where he requested the ladies to provide with their passports, their passport size photos. He would give conditions that the ladies were to go for HIV tests, and the test that is submitted should be negative in order for them to secure employment in Kuwait. He recruited a number of ladies, and from the case when he was arrested, about 36 victims of trafficking were repatriated from Kuwait after these ladies had to run away from their employers and sought refuge at the Zimbabwean embassy. The accused person employed these, or rather trafficked these victims on the pretext of what, as the state, we looked at deception and fraud, because he told the victims who were vulnerable and desperate job seekers, and who thought that by going to Kuwait, they would be moving to greener pastures in order to fend for their families, because most of the ladies, they came from poverty-stricken backgrounds. So he offered lucrative salaries, and from the evidence of the witnesses in court, they testified that he actually made those ladies to sign contracts, and during the trial, we even tendered those contracts of employment that were signed between the accused person's employment agency and these victims. And from the contracts of employment, there were salaries, they were written to the tune of 70 KD, which is the currency in Kuwait, and this was equivalent to 250 United States dollars. Another working conditions which were on the contracts were that the victims were promised that they will be working normal working hours, which was 8 hours a day. The contracts also stipulated that the victims would be afforded their leave days or vacation days. So we find that the accused person lured these women and trafficked them to Kuwait. The accused person also processed the visas for the victims. He would collect their passports and process the visa and return the passports to the victims with the visa endorsed. He would also process and pay for the airfares of the victims, and he would accompany the victims to the airport, let them board the train and the plane, pardon, and they would go to Kuwait. Upon our arrival in Kuwait, we established during the case that the accused person was working in connection with another employment agency in Kuwait, and the officials of that other employment agency in Kuwait would, once the victims arrive at the Kuwait airport, they will welcome the victims and immediately confiscate all their travel documents. They would confiscate all their phones and everything. And the victims also testified that from the airport, they were taken to a certain place where they were made to stand in a queue or in a line, and a number of employers would be there present, where they were made to stand in some form of slavery, or to some manner like they were being sold, whereby an employer would come and pick the person whom he or she would want to go and employ as a housemate at their house. The working conditions under which these victims were working under were very harsh. The victims testified that they would work for at most 15 hours a day. They would wake up at 5 a.m. and would only go to bed way after midnight. The victims also testified that they were restricted to movement and to communication with the outside world, since whenever they reached the airport, all the cell phones were taken and their documents were taken, and they were not allowed to leave their employer's residence. The victims were also limited to food. To some of them who said that they would not eat up until all the employers have eaten. Some even testified that they survived on leftovers, and some had to be given food by other employees who would be also employed in a form of labor exploitation at those premises. You would also find that the victims in this case did not have proper places to sleep, and some of the victims even testified that at times she would even spend the night standing, because the place she was given to sleep was so small that it was not enough for her to sleep. So as I initially indicated, the accused person when he was arrested, or rather maybe The victims some of the victims who testified indicated that they were in contact with the accused person. I had about 2 of the 6 victims who indicated that one of them was given a cell phone by a gardener who was working at the same premises as her, and the only contact detail that she had was that of the accused person. She contacted the accused person and advised him that those were she was subjected to such harsh working conditions in Kuwait, and as they were promised, they were not getting the salary that he had promised, or that he had promised them and made them to sign contracts. But from the testimony of the victims, the witness told that the accused advised them or promised them that he will secure alternative employment to another alternative employer who would have better working conditions. And in some of the victims, there are about 2, he was successful in moving the victim from one employer to the other, but still the working conditions did not change. They would even get worse, as one of the victims was even subjected to physical abuse. She was assaulted, victims were subjected to verbal abuse, and there was language barrier. And one of the witnesses even testified that there was an attempt of sexual assault on her. The accused person was arrested after one of the victims fled from the employment where she was to the Zimbabwean embassy in Kuwait, where the Zimbabwean officials and the Zimbabwean ambassador worked in hand with a team of police officers who even went there in Kuwait, and they managed to rescue most of the Zimbabweans, who were then placed in a shelter and eventually repatriated back to Zimbabwe. The accused person was charged with 36 counts of human trafficking in terms of the Zimbabwean Trafficking in Persons Act, in particular Section 3, subsection 1B, subparagraph 1 and 2. But it was unfortunate that out of the 36 counts that the accused person was charged with, I only managed to prosecute him for only 6 counts. Reason being that the accused person, he was arrested in 2016, and he was granted bail by the court. And as soon as he was granted bail, he defaulted, and he disappeared for about 2 years and was only arrested in 2018. So within those 2 years, a lot happened to the victims. Some of them were no longer willing to testify. And the funny thing in this case is that some of the victims were even sympathizing with the accused person, as they were saying that he was the one who had actually taken them to Kuwait, and as some who received their salaries actually wanted to go back there, and as they had seen that the accused person had removed them from their poverty-stricken background. So we had a challenge, but we successfully prosecuted him for 6 counts of human trafficking, as 6 victims came forth. The accused person was prosecuted and sentenced to 10 years imprisonment. You would find that, which was the minimum sentence in terms of our act for human trafficking, where it is committed without any aggravating circumstances. In our law, what we regard as aggravating circumstances in human trafficking includes trafficking of disabled persons, trafficking of children, and we also consider whether there was any death of the trafficked person. So in this case, there were no children, there were no victim passed on, so there were no aggravating circumstances, and was only sentenced to the minimum 10 years imprisonment. In sentencing the accused, the magistrate treated all the 6 counts as one, as she indicated that all the facts of the 6 counts were similar. That was her reasoning for sentencing the accused person and for all 6 counts as one. From the case, there were some issues arising. The first was the need to distinguish between unfair labor practices and labor exploitation. In his defense, the accused person told the court that one, he operated a registered employment agency, and two, the accused person had signed a contract of employment, and if there was any unfair labor practices, they were subject to unfair labor practices in Kuwait, and they had to make their report there in Kuwait. That was the defense of the accused person. However, the court and also the state submitted that the act did not constitute unfair labor practices, but rather was human trafficking, and it constituted labor exploitation, taking into consideration the manner in which the accused person was transported to Kuwait. We also noted that the victims were subjected to bonded labor, which is also provided in our act as a form of labor exploitation, because from the evidence, the victims were supposed to reimburse the employer, because it was the employer who paid for their airfare to go to Kuwait through the accused person, James Marodza. So the accused persons were subjected to bonded labor, as they had to reimburse the employer money for the ticket, for the airfare ticket, which they had used to go to Kuwait. We also noted that there was forced labor, because the victims were subjected to unfair labor practices, and some of them did not receive their salaries. The accused person also demanded a certain percentage of the victim's salary as payment for what I can say in court, his services for recruiting them, where the victims testified that the accused person requested that each month each victim should send an amount equivalent to 50 United States dollars as a payment for his services, to which in all the evidence, only one witness managed to pay the accused person, and in the trial, the accused person was actually demanding that the victims owed him payment for his, which I found quite strange in his defense, that the victims actually owed him payment for his services where he had recruited them to Kuwait. Another issue, that arising is that our law, or rather the law, in particular the protocol, does not provide a clear definition of labor exploitation, but in our law, or in prosecuting James Marodza, we managed to include the issue of labor exploitation, taking into consideration Section 2 of our Trafficking Persons Act, which defines trafficking of persons for unlawful purposes as to include for the purposes of prostitution, child or adult pornography, unlawful removal of organs, and it also includes illegal labor, forced labor, and other forms of servitude, which were some of the issues raised and were addressed by the court in the case. Another issue arising in the matter of James Marodza, which we noted is rather a challenge that arises is the issue of identification of victims trafficked for the purpose of labor exploitation. The victims may sometimes fail to identify themselves as victims. They will be thinking that they will not be seeing themselves as victims, but rather persons who would have been taken only for employment purposes. because we find that in the James Marodza case, even when the embassy went to repatriate, some of the victims actually remained in Kuwait. And those were the ones which were receiving salaries, and they thought that maybe the conditions in Kuwait were better than coming back to Zimbabwe or coming back home, where they did not have any source or means of living. Another issue which also arises in the exploitation for the purposes of trafficking for the purpose of labor exploitation includes the issue of consent. The accused person raised in his defense that the victims had consented to go to Kuwait, but our law provides that consent is not a defense. So in as far as he would say that the victims consented to go to Kuwait, we argued that consent is not a defense, and then that he cannot say so. Another issue arising was that the victims were dependent on the perpetrator, on James Marodza, because as I've highlighted earlier on, the witnesses, some of my witnesses, even when I was leading them, had to go an extra mile of thanking the accused person, which I find odd, because he was the only contact person that they were in contact with while they were in Kuwait. And they would inform him of the employment conditions that they would work under, and the accused would encourage the witnesses to hang on. He would persuade the witness that he would transfer them from that employer to the other, and at times would the victims in testifying indicated that he even comforted them that everything was going to go. So that was another, the major challenge that we had in terms of the issues arising for purposes of labor exploitation. And lastly, we also noted that in trafficking for labor exploitation does not involve only one person, like in this case of James Marodza. It involved a syndicate as he worked with employment agencies in Kuwait. Although in our case, we endeavored, we tried by all means for the police to, when they went to Kuwait, to maybe locate the other agency who was working with James Marodza, but we failed. We also failed to actually find out what the accused person was benefiting besides getting a percentage from the salary of the victims. We were trying to get a link of what the accused person was actually benefiting from the other employment agencies in Kuwait. Yeah, so that's basically it. And maybe lastly, another issue which arose, this is the last point, the last one, which arose in the issue of James Marodza. We addressed the issue of unfair labor practices versus labor exploitation. The accused had given a defense that he operated a registered employment agency, and we had to call the evidence of an expert from the Ministry of Labor and Social Welfare for them to comment on the authenticity of his employment agency, as well as whether he was allowed to employ outside Zimbabwe, which evidence also assisted the court in arriving at an informed decision, because the Ministry of Labor was testified that his contract was, or the perimeter of employment was within Zimbabwe, he had no right to extend employment outside Zimbabwe. Therefore, what he did amounted to human trafficking. That will be all. Thank you.
Thank you very much. Let's give the panel a very big round of applause. It's been quite a heavy shift, hasn't it, the graveyard shift? But thank you for your patience. The end is in sight. Just because we've been sitting and listening for quite a while, does anybody want to make a comment before Rahel comes in and wraps everything up? We're going to lose you if we don't give you an opportunity to express yourselves. So for the next 10 minutes, do we have any issues that we want to comment on? We've heard from 2 cases that are live. They are still going on. If anybody has any words of wisdom to impart to our colleagues who are still in the process of arguing their cases before the court, now is your chance. But we've also heard from our colleagues from cases that have already been decided, very interesting cases. We've had an actual prosecutor who prosecuted one of the cases, and it's been quite interesting to hear her insights, especially as to how the victims perceived themselves. You know, victim identification is quite a challenge. If anybody has any comments, now would be the time for us to speak a little bit rather than listen the whole afternoon. As we say, speak now or forever hold your peace. Thank you very much, Mozambique.
Boa tarde. Foram apresentações muito ricas e longas, porque foram muitas, mas eu queria fazer uma questão para Angola, não devolvendo a questão que nos fizeram pela manhã, mas porque Angola tem um sistema jurídico parecido com o nosso, se não o mesmo. Eu queria perceber se Angola, quando faz as investigações de tráfico de pessoas, faz uma investigação financeira paralela e se investigam também o branqueamento de capitais, porque eu percebi que tinha tráfico, indiciaram por tráfico de pessoas, mas que possivelmente também por associação criminosa, auxílio à migração ilegal. A minha dúvida era, também investigam branqueamento de capital e utilizam o crime de tráfico de pessoas como um crime precedente para estes crimes, porque o que nós temos estado a perceber é que se nós fizermos muitas vezes uma investigação financeira paralela, quando detectamos esses casos de tráfico de pessoas, podemos a partir daí conseguir chegar aos mandantes, porque muitas vezes encontramos os traficantes, mas não os mandantes. Então, pela investigação financeira paralela, é possível conseguirmos muito mais provas. Então, queria perceber de Angola se estão a fazer isso e como é que agem nessas matérias. Obrigada. E outros também, se quiserem efetivamente responder a essa pergunta.
Queria aproveitar também, como a minha colega acabou na sequência da intervenção da minha colega, em primeiro lugar, parabenizar também a todos os colegas que fizeram as apresentações dos diferentes casos nos seus países, desde ontem até hoje. São casos realmente muito importantes e cada um deles tem lições que nós devemos apreender. Também a minha questão era para Angola. Nós gostaríamos de saber se Angola já tem uma lei específica de proteção de testemunhas. Há sensivelmente 3, 4 anos tive a oportunidade, penso que foi há 4 anos atrás, tive a oportunidade de deslocar-me a Angola, que era para exatamente partilhar a experiência do Moçambique na aplicação da lei de proteção de testemunhas e precisamente da proteção de vítimas de tráfico de pessoas. Então gostaríamos de saber qual é o ponto de situação nesta matéria em relação a Angola. Outra questão tem a ver com um caso que foi apresentado. Pelo historial, constatamos que são vítimas, portanto, que provém de um país, de um outro país, portanto, Nigéria. Nós gostaríamos de saber se estas vítimas, se ainda há um trabalho que está sendo feito para que estas vítimas possam retornar portanto, ao seu país de origem, se ainda não retornaram, e se Angola, da mesma forma que Moçambique, se tem no seu Código de Processo Penal a possibilidade, portanto, de fazer que as vítimas possam prestar depoimento antes mesmo da realização, portanto, do julgamento, portanto, a produção portanto, para memória futura, que esses depoimentos depois podem ser usados em sede de julgamento, mesmo que as vítimas não estejam fisicamente presentes nessa altura. Muito obrigada.
Thank you very much. Yes.
Thank you very much, Lady Justice. Just to follow up on the question that Amabelia raised regarding, victim support post-trial, and I'm curious to see whether there's any member states here who offer sort of victim support post the trial. I know that, of course, the scope and capacity of the prosecutors might wind up really during sentencing and during judgment and sentencing, but I'm curious because, the trauma of the victims and the victims' welfare really goes over and beyond just the sentencing. And I'm wondering if there's any cases, examples here within the room, or if there's any framework by member states which offers sort of victim support post-trial or in partnership with the prosecutorial office or the court and social services, etc. So not really limited. Happy to hear from the panel here, but also from colleagues around the room if there's anything, any framework like that. Thank you very much.
Muito obrigado. Bem, relativamente às questões que nos foram colocadas pelas nossas irmãs do Índico, eu ia começar por responder à questão da lei que tem que ver com a proteção das vítimas. Devo dizer que felizmente já temos uma lei, é a Lei 1, é a primeira lei aprovada no ano 2020, a Lei 1/20, que trata da proteção das vítimas, testemunhas, arguidos, colaboradores em processo penal. Nesta mesma lei, podemos encontrar também a resposta à segunda questão que coloca, que está relacionada com a possibilidade das vítimas poderem ser ouvidas antes mesmo do julgamento e posteriormente serem utilizados esses depoimentos nesta fase. Questão um pouco mais difícil, prende-se com a questão para o pleonasmo, a situação do branqueamento de capitais. Eu trabalho no Serviço de Investigação Criminal e nós, quando estamos a investigar tráfico de pessoas, investigamos tudo o resto, não é? Mas devo dizer que tem sido muito difícil condenarmos alguém em Angola por branqueamento de capitais. Muito difícil. Aliás, não sei se já temos, parece não haver agora um caso julgado, transitado em julgado, não é, nesta matéria. Tem sido um desafio e tanto. O Estado angolano tem estado envolvido na capacitação dos seus quadros, mas nos parece haver também alguma limitação legal que certamente as entidades competentes estão a trabalhar para poder resolver essa questão. E quem coloca essa situação com o tráfico de seres humanos, ou de pessoas, se quisermos, poderá fazê-lo também com o crime de peculato. O famoso crime de peculato em Angola, alguns especialistas entendem que o crime de peculato não é tido como um crime precedente ao branqueamento de capitais. E como podem imaginar, isso cria imensas dificuldades no nosso trabalho para podermos condenar alguém por essa prática de branqueamento de capitais. Mas o que lhe posso dizer é que, quando surge um caso de tráfico de pessoas, nós investigamos todos os outros ilícitos que podem surgir. Obrigado.
Quanto à questão sobre... Bom, vou ainda dar aqui algumas considerações sobre a questão do branqueamento de capital, sobre o que aconteceu de facto neste processo. É que essas vítimas, elas foram colocadas também a trabalhar em algumas lojas no mercado que nós referimos, não é? Fez-se uma investigação sobre a documentação, o alvará dessas lojas, onde elas vendiam os produtos no mercado, e não se conseguiu trazer nenhum elemento ao processo que pudesse fazer prova de que haveria ali também subjacente um crime de branqueamento de capitais. Relativamente ao trabalho que está a ser feito para um eventual retorno das vítimas para a Nigéria, temos a dizer que a investigação ainda está em curso, há diligências que ainda estão a ser tomadas, e as próximas que serão feitas será de facto colher as declarações dos pais das vítimas para o processo. Isso infelizmente vai ter que ser feito por via de cartas rogatórias, esses expedientes que são um bocado demorados, e com base nisto nós vamos de facto avaliar qual é a possibilidade que teremos de as enviar novamente para a Nigéria. É tudo. Obrigado.
Thank you very much. Banele wanted to make a comment before we hand over to Rahel.
Thank you so much, Judge Fiona, and thank you so much to everyone. Well, basically, it's just, it's not a question, it's a comment, Judge Fiona, you know. I've been listening to the discussions, and it came to my mind, just to say, I wonder how, to what extent do the prosecutors work with investigators? I will imagine that trafficking and persons cases basically start with the investigations, and the prosecutors will then prosecute. To what extent do prosecutors in their respective countries guide the investigations of trafficking and persons cases? Because I will assume that prosecutors are not investigators, but rather probably will guide investigations to a certain extent. And if there are any challenges whatsoever or collaboration issues with investigations, and also how in their respective member states do prosecutors have capacity building workshops with investigators? Thank you. I say this in light of the fact that I am not aware if there is an investigator in this room. Thank you so much.
Thank you very much, Banele. There is a hand up from Namibia, but I do know that, there's also another hand up from Eswatini. I know that there are several police officers in our midst, so I'll give you an opportunity to respond in the order that I've called you, and if we could also hear from one or two police representatives, and then Rahel can wrap up.
Thank you. In Namibia, there are certain cases that are subject to guidance by prosecutors. It's called prosecutor-guided investigations, and trafficking in persons is one of those offenses. Currently, what is happening with all the cases of trafficking
in persons that are detected by the police, as soon as they suspect that there's a trafficking in persons case, even when there's just one statement in the docket, they refer that to the prosecution to guide the investigations. Okay, we don't remove the original docket from the police to just so that we do not derail their investigations. What we ask them to do is to provide us with a copy of the docket, and from the copy, we can continue guiding them with their investigations. And that seems to be working well for us so far. So that is the method that we are using in Namibia. Thank you.
Well, thank you, my lady. With regards to the Kingdom of Eswatini, we have the task force, which is made up of the Secretariat. In that, we have investigators and the Secretariat and the prosecutors in terms of investigation of that matter. So once the matter is identified, we are informed by the investigators so that we are able to guide them on how to investigate those cases and on how to ensure that we get sufficient evidence so that we can be able to properly take the matter to court. And there was a question that was asked by, I forgot it, as to how do we handle the victims of trafficking. Recently in our country, we have just enlisted shelter guidelines, in as much as we have the witness protection plan. There's also now the shelter guidelines. And those shelter guidelines that we are now taking care of, they are for the victim care, support, and assistance, which is aimed at giving the best protection to the victims and ensuring provision of services to the victims. These guidelines are to be pointed from point of identification of the potential victim to the end wherein the victim is integrated to the society or to the country of origin. And those guidelines are to the best interest of the victim, such that there should be the rights or the human rights of that particular victim should be taken into consideration, and the consent of that victim with regards to whether or not she wants to be kept, and the duration of time after giving evidence, so that they are kept in those shelters, so that they are prepared for court, taken to hospital if there's a need for them to be taken to the hospital, and they also given respect in terms of getting clothing, because in most instances you find that they ran away from that situation with nothing but the clothes that they are wearing. So such things have to be taken care of. Thank you.
Thank you very much. Any of the police officers in the room want to contribute to investigation? Yes, Malawi, I see a hand from Malawi. Anybody else? And Mauritius. So we'll start with Mauritius. They had their hand up first, and then we'll finish with Malawi.
Yes. In respect of trafficking person, being given that by the nature of the complexity of the offense, we at the police prosecution level, we encourage investigators to get in contact with the office of the DPP. We work in close collaboration. We also organize capacity building on the subject as regards investigation, so that once the inquiry is completed, we do not lack element to prove the offense. We work in close collaboration with the office of the DPP, and we encourage investigators to work with the state law office. Thank you.
Thank you very much, Malawi. Finally, Mozambique.
Thank you so much. For the corroboration between investigators and prosecutors in Malawi, I think first of all, you should be aware that in Malawi we still have prosecution being done at the police level as well as at the Directorate of Public Prosecutions. But most of the prosecutions in the lower courts, in the magistrates' court, are done by police prosecutors. And as you are aware, the investigations themselves are also done by police officers. Therefore, at each and every police station, you have investigators and prosecutors skewed there. Therefore, it's not very difficult to work together between the investigators and the prosecutors. And once a report is made or a detection is made of an offense involving human trafficking, usually the investigators and the prosecutors will be aware, and from the initial stages, they will work together. The prosecutors mainly to guide the investigators, especially in ensuring that the elements of the offense, as they go about investigating the matter, they're able to come up with the elements of the offense so that when the file is completed, it becomes very simple for the prosecutors to take it before the court. And secondly, I think it also depends on the complexity of the cases. There are some cases which are complex, and in those cases, sometimes also we may involve state advocates from the Directorate of the Public Prosecutions to help in guiding the investigations. But generally, because most of the prosecution is done at police level, you find that there is that already working relationship between the two entities. Thank you so much.
Thank you very much, Malawi, and finally Mozambique.
Obrigada. No caso de Moçambique, sempre que ocorre, no caso, crime de tráfico e a polícia, no caso, o Serviço Nacional de Investigação Criminal, tem conhecimento desse crime, instaura o processo e dá conhecimento imediatamente ao Ministério Público. E esta investigação que é levada a cabo pelo Serviço Nacional de Investigação Criminal é realizada sob direção do Ministério Público. Isso quer dizer que o Ministério Público acompanha toda a investigação, incluindo, recomenda e ordena a realização de diligências que entende ser importantes ou relevantes para a descoberta da verdade e formação daquilo que nós chamamos o corpo de delito. Recentemente, nós tivemos uma alteração na lei orgânica do Ministério Público e foi criado um gabinete de combate ao crime organizado. Uma das tarefas que este gabinete de combate ao crime organizado, onde tem, para além de procuradores, também estão investigadores, vai investigar casos de tráfico de pessoas, por exemplo, que não só tenham alguma complexidade, mas tenham também conexões portanto, internacionais. Sempre que houver uma situação de um tráfico de pessoas em que existe um número elevado de intervenientes, não só, existe também conexão com outros países estrangeiros, portanto, será esta equipe, ao nível deste gabinete de combate ao crime organizado, que vai realizar a investigação até ao seu final. Obrigada.
Okay, thank you very much. I think at this point, we now hand over to Rahel to give us a roundup and concluding analysis.
Okay. So first of all, I want to tell you that they were very impressive presentations. And it was very exciting to have one of the prosecutors, or the two even prosecutors who actually are handling cases appear before us. I'd like to first address trafficking for labor exploitation. And here, these are very difficult cases for many reasons. First of all, factories, farms, private homes are not the usual arena of police officers. Police officers are used to arenas like prostitution, okay? They're familiar with that. But in labor exploitation cases, as we see in the Alam case, they require coordination. They require coordination between labor inspectors, sometimes immigration officers, sometimes Ministry of Health functionaries, and the police. Because otherwise you don't get the cases. As several of you mentioned, there are not many complaints. In one case, there was a tip-off, and in the Alam case, we see the coordination very clearly. There was a complaint to a tip-off to the Ministry of Immigration, who referred it to the Employment Department, who sent investigators, who in turn turned to the police. So that's one reason why these cases are difficult. Second of all, often the places in which the victims are held are isolated. We see the best example of that in the Shangwa case. This man was on a farm far away from anybody else, no support systems. Who would have really known of his existence? Also in Maruda, the young women in a foreign country, in Kuwait. Thirdly, there tends to be a normalization of the exploitation of foreign workers. We see that all over the world. People are used to paying foreign workers less. They're used to seeing very bad accommodations for foreign workers. This becomes normalized. And if it becomes normalized, you don't get complaints from the public. You don't get lots of tip-offs from the public. So all these things create problems in pursuing trafficking for labor exploitation. Now, the truth of the matter is that the question of question, the issue of issues in trafficking for labor exploitation is the one that Val posed. When do labor violations make the leap to trafficking? Okay? And I think that the cases that were described here show us how they make the leap. Here, the totality of the evidence is the best way to evaluate a case. We see that in most of the cases which were presented, we have inhuman accommodations. We have long hours of work. We have restrictions of freedom, which is a big red alert. We have non-payment or very low payment. We have acute vulnerabilities. We have isolation. We have deception. We have debt bondage. So when you have a constellation of such circumstances, this makes the leap to trafficking. Another point that I want to make is the more the case departs from your labor laws, so it is more likely that you'll get a conviction. In other words, if you have a minimum wage of, I don't know, $1, I don't know, $2 an hour, and you see that the person got 1 cent, okay, or got nothing. If you have a labor law that people should be working 8 hours and they're actually working 23 hours, which is a case that we had here in Israel, then you have a stronger case. That's the second point I wanted to make, and the most important. And I also want to note that one of the most common defenses in trafficking for labor exploitation is consent. And we saw in several cases that the victims actually said they wanted to stay. We see in Val's case that they actually went back to the abusers. We see in the case from Angola, the children want to stay, okay? And don't necessarily see themselves as victims. So this is something which we have to realize that arises in these cases and know how to deal with. Another thing I want to note is most of the cases we've dealt with up to now have had female victims, okay? But these labor exploitation cases include male victims. And it's very important for us to realize that, yes, there can be male victims. And we shouldn't limit ourselves to females. And that's why, in some way, when trafficking departments are in the context of gender, it tends to maybe blind us to the fact that men too can be victims. And here I actually want to read you something from the Global Case Digest, which I think that I also included in the Regional Case Digest. This was said by a practitioner from the United Kingdom. And she says this way: men often do not want to expose their physical or mental ill treatment, fearing that they will be seen as weak. And therefore, what men tend to do, if they ever complain, is complain about salary. Why? Because that is not a reflection of who they are, but of what if someone else has done wrong. So I think another lesson here is when men do complain, they will probably tell the story like the peeling of the onion. They will tell you they didn't pass, and one has to dig deeper. And then one will perhaps reveal that their freedom has been restricted, that they've been assaulted, all kinds of things which they don't tell at first. I also want to note that we need to realize that not all cases of labor exploitation require violence, okay? Some of these cases had no violence. The Alam case, for example, had no violence. The Maruda case, the prosecutor told us that in one case there was an assault, but the other cases there wasn't. So we need to realize that violence is not a requirement, okay? And I really would refer you, in terms of forced labor, to a document I really, really love. This is the International Labor Organization's document, which is called The Cost of Coercion. And if you look at page 24 of that document, you'll see clearly forced labor, even though it has the word force, does not require force. It's enough to have subtle means of coercion. Okay, so that's as far as labor exploitation, what I wanted to say. As far as weaknesses in cases, I wanted to point out two weaknesses which were dealt with partially by you, but I'd like to maybe broaden it. First of all, individual reactions. Sometimes we have before us cases in which victims react in different ways. And as my colleague John Cotton Richmond says, which a very powerful statement, victims come in many shapes and sizes. The reaction of one victim does not foretell what another victim will react. And it shouldn't affect their credibility, okay? Because one could say, oh, this victim actually was able to refuse. So the fact that the other victim consented or didn't express her or his objections means that either he consented or he's not credible. So I want to point to a few cases in your region which have these individual reactions. One, I have an echo again, which is problematic. Okay. So one is the Lucas case, which has been dealt with by the Namibian prosecutor. In the Lucas case, the two minors reacted in very different ways. One of the minors, I think the 14-year-old, was covered with shame. Okay? The other one, her senses were blunted. She considered the sexual exploiter to be her boyfriend, and she actually wanted to continue the relationship with him because she derived economic benefits. These are different reactions. These are different victims. Neither is non-credible. In the Mahoney case, we see that one victim actually refused to perform some of the sexual acts, and she was returned to her country of origin, but the others did agree to do that. I wouldn't say that any of them were non-credible. I wouldn't say that any of them really consented, genuinely consented. And indeed, there was a conviction there. In the Mabuza, South African case, it's a very interesting case. One of the 5 children was raped one time, but thereafter, every time they wanted to take her to the sexual exploiter, she claimed that she had her menses. So she was raped once. The other children were raped numerous times. These are different reactions. It doesn't mean that some of them are non-credible. It doesn't mean that some of them consented. Now, another thing that I wanted to address, and the last thing, is something that I don't think we addressed yet. It's delayed complaints. Now, usually, if someone delays their complaint, we see them as non-credible. We see them as weak, because if something really heinous had happened, they would have complained. Now, we know in the literature on sexual offenses that this is not the case. Very often in sexual offenses, victims do delay their complaints because of the trauma, okay? But this is also the case in trafficking. And here I would like to again refer to the South African Mabuza case, which is a very extreme case in this respect. 5 children, 4 of them told the prosecutor and the police everything that had happened to them. 1 did not. 1 said that this had been done to the other children, but not to her. When did she finally complain? When the prosecutor had wrapped up everything and the investigation was concluded, he was on the point of preferring the charges. Only then did this girl come forward. And why? And here there's a big lesson for prosecutors. She said because she saw she could trust the prosecutor. Now, we know that trafficking destroys trust, especially if family members are involved, or neighbors or friends. Destroys your trust in the world. The prosecutor in these cases has a wider role than in other cases. He must obtain the trust of the victim. If he doesn't, he won't have a good witness, aside from the fact that, of course, we do want to restore the trust of victims in the world. So she complained very late. She also explained that she was ashamed. She was ashamed. This was a sexual assault which has a stigma. She was ashamed that this happened to her. So delayed complaints are not necessarily a weakness in the case if the prosecutor takes the trouble to get the victim's explanation for it. Okay, that's about all I have to say. If there are any questions, I would be happy to address them.
Thank you very much, Rahel, as always, for giving that that human feel to the faces that we never get to see But when you've worked as long as you have on these cases, you have such an intimate knowledge of them that we are always grateful, to hear from you what emotions were behind the victims and how these emotions and how their reactions and how the circumstances add up to not only the elements of the crime, but to giving us a full picture that makes up the building blocks of evidence for the case. So thank you again, Rahel. We've now come to the end of the day. I'm going to ask Jeptum to come and talk to us about the logistics from here on. I think we never acknowledge ourselves. We should also give ourselves a round of applause for all our contributions and for sitting patiently.
For your participation to date. Indeed, has been a very long day and very, very intensive. So thank you very much. Tomorrow we have a relatively short session, which I think is good so that it can give us time to go and see how South Africa looks like outside of these four walls. Looking at the agenda, it says that the program ends at about 3 o'clock, but I think if we put in a lot of effort, we can try to push and finish as we break for lunch and call it, if we agree with that. We are all about democracy here, so I follow your lead. So we'll begin as today, 9 o'clock. I'm very grateful that today you are all very punctual. So if you can be here tomorrow at 9 o'clock, and we will start with a very short panel. We have Malawi, Zambia, Republic of Namibia, and South Africa as well. So I think this will be fine. We can do it as today, have an hour session, and then a wrap up. Then I will propose that we do not have a tea break. We proceed again with the next session, which focuses on victim protection, which is, I think, a very key issue that came out even from these sessions this afternoon, a lot as well from the reflections of the Republic of Angola. Therefore, we'd have the Kingdom of Lesotho, South Africa again, and the Republic of Zambia. Then we will see how the morning is going, whether we will have a Rahel come in to have the discussions on exoneration, so we have a tea break and then have this discussion from Rahel, because it might be a bit long, it will take about an hour. Then we can have a recap of issues, which can also involve us having any questions that arose from the sessions today, any observations. And most importantly, ladies and gentlemen, we'd really like to take this back to your countries so that we can broaden this engagement of prosecutors within your member states and also bilaterally. There's some issues that are peculiar to a region in South Africa. Maybe two countries have similar issues. Like today we've seen this a lot of nexuses between Angola and Mozambique, particularly because of the similarities of the legislation and the processes. So we are very happy to facilitate a learning exchange between these countries, between you two, or countries that border each other, etc. So really, if you can just think about it when you can have these reflections so that we can take them as way forward tomorrow, and then we can also tie ourselves to see how we can advance it, including tying us for our obligation to work with you on this. And then I think we can end it very early tomorrow. And I call it a day here today, ladies and gentlemen. I thank you so very much for your participation and have a good evening. See you tomorrow. Bye-bye.